Good morning, gentlemen. I'm sure you have agreed how to carve up the remainder of the time.
And we considered that the most simple way, my lady and my lords, was for me to continue with the appeal, and Mr. Knox will respond so that the appeal is dealt with, and then Mr. Knox will deal with the cross-appeal from the respondent, and that's probably the most sensible way. And I'm going to be mercifully brief in relation to grounds 2 and grounds 3. You will recall, my lady and my lords, that they are contingent upon success on ground 1. And they are both accounting and numeracy points, if I can sort of put it loosely in that way. Now, the point in terms of ground 2, there is a tension between the profit share agreement and also the sale and purchase agreement, which we haven't really looked at yet in this appeal. And it's in particular, it's 10.3, clause 10.3 of the 2012 SPA, which is in the supplemental bundle at page 92. The actual agreement's at 59. The page that I wish to draw this court's attention to is at 92. It's right at the bottom of that page. And this is the... Just wait to see if everybody has got that. Then at 10.3, it deals with costs and expenses. And over the page at 93, it says, save as otherwise set out in this agreement, all fees and expenses incurred in connection with this agreement and the transaction shall be borne by the party incurring such fees or expenses. Section 7.1c is reserved. That's actually of no relevance. It doesn't actually apply in this particular situation. So the idea was that the costs in terms of MGI preparing in terms of due diligence and the preparation for entering into this agreement should fall, and they should pay for that, and everyone's costs should lie where they fall. The learned judge made a number of deductions under clause 3.3 of the profit share agreement. And if I can take you in the core bundle to...
I just ask what 10.3a refers to the agreement and the transaction, capital T. Is there a definition of transaction?
There is, and that is defined in recital 1 as the acquisition of the Soto and Campo shares. That's at page 78, my lord.
Right. 78?
Page 78 of the supplemental bundle. And if one looks at I, about a third of the way down the page.
All right. Okay, thank you.
And the simple point is that clause 10.3 provides that the costs of preparing for the 2012 SPA should be borne by the party that incurred those costs. Now, if one turns now in the core bundle to page 102 and 103, and what I'm looking at now is paragraphs 258 over to 259 of the judgment. What the learned deputy judge said at 258 is once again adopting a broad reading of 3.3.4, that's of the PSA, can encompass professional costs incurred for the purpose of the acquisition of the real estate assets through the purchase of Soto shares, as well as costs incurred during the period that MGI held the Soto shares. I said that such an interpretation would be contrary to 10.3 of the 2012 SPA, which provides that all fees and expenses incurred in connection with 2012 SPA and the transaction shall be borne by the party that incurs those fees or expenses. And then in the next paragraph, we see that the judge does not agree with my submission. He says that clause 10.3 is dealing with the question as to which party bears the immediate cost of the sale and purchase of the Soto and Campo shares in 2012. It provides that those costs should lie where they fall. And then he goes on to say that 3.3 is determining the amount of any element of the consideration for the sale and purchase of the shares, not to my mind inconsistent with 10.3 for 3.3.4 to allow MGI a deduction in computing its net profit for the costs that it had to bear, in particular if I'm adopting a broad interpretation of 3.3 as I am. Now we say that was an incorrect approach, because what it allows for, it essentially means that MGI was able to deduct 4 elements of costs that were essentially pre-transaction costs. And we say that that reasoning is incorrect, because MGI gets its pre-transaction costs back post-sale.
Sorry, can I just intervene for a second?
Yes, Mark.
I just want to try and get my chronology correct and also the terminology correct. The chronology is that the novation and amendment agreement to the SPA dated the 21st of September 2010. Is this right? This is a document which was dated when? The novation and amendment agreement.
24th of October 12.
Sorry, my lady.
24th of October 12?
That's right.
So,
and we see at page 59, my lord, the various dates that it's been amended. One can see, if you recall, I mentioned yesterday morning how the strike group,
right. So
it kept getting pushed off because the strike group weren't able to actually purchase it. And then MGI enters into the negotiation to purchase the shares, and that occurs in October of 2012.
right. So 18th of October 2012.
Yes.
Novation and amendment agreement, including clause 10.3.
Yes.
So all fees and expenses incurred in connection with this agreement, that's for sale of Soto
And
Campo.
Yeah, yes, the acquisition.
And the transaction, which
Yes.
is for the sale of Soto and Campo.
Yes.
Is that right?
Yeah. Yes. Well, the transaction, you'll recall, is defined at.
Yeah, holdco is Soto,
Yes.
as defined. I
Yes.
haven't found the definition of holdco, but
That's
I
right.
assume that's Soto, right?
Yes.
Shall be born. And then, is this right? What is, if we then look at the profit sharing agreement, it's 3.3.4 is that we need to be looking at.
That's right. And what the learned judge did was.
So the relevant clauses, any legal accounting or other professional fees incurred in connection with the relevant real estate asset. Is that the heading that the judge has?
Yes. And he's given that a broad meaning and allowed, and this is where I'm going to come to the 4 specific items that I challenge, that he's allowed the KPMG due diligence report, the DLA due diligence report, and a CBRE valuation report to be deducted, that that MGI instructed those 3 professional firms to carry out work for it in advance of the 2012 SPA. And we say that that was an error.
And okay, but this is on the footing that real estate assets as defined include the shares in Soto for this purpose.
Yes, but it's also but the primary submission is that the profit share agreement, the idea is that it's what can be deducted is what MGI spend on that real estate asset during its period of ownership of Soto and Campo, in that case of Soto, because so that, for example, in the period 2012 to 2015, if they instructed a surveyor to value the land or accountants to prepare annual accounts, those sums can be deducted. But what can't be deducted is a sum that led up to the 2012 acquisition itself. Because effectively, JOP would be giving back upon the disposal of the asset, would be effectively knocking off the money that they'd already spent and deducting that they'd already spent in advance of the 2012 acquisition, so they get the money back. And we say that can't have been what the parties would have, what these agreement and what that tension between what 10.3 contemplated. Effectively, JOP is footing the bill for some professional costs. Can I take you at 113? The judge set out there in the table of deductions. Can I take you to the four items that are actually being challenged? I've set those out in paragraph 63 of our skeleton. So it's item 16.
And you say that's the paper that we've been referred to. There were the two due diligence, one legal and one KPMG.
Well, I say that's part of it. We've only seen part of it, my lady. But yes,
that's an extract from it. Yes.
Exactly. So that's number 16. Then I say number 22, the DLA Piper, and it says the transaction lawyers.
Sorry, I'm lost as to where you're running from. Sorry.
I'm sorry, my lord. I'm 113 of the core bundle, and I'm in the judgment. There's
the core. Sorry.
Core bundle.
Sorry, core. Sorry. Yeah.
Let me just go back, my lord.
Yeah, I've got it.
Number
sorry.
16.
I was just in the wrong one.
Yeah.
Sorry.
Number 16 was the first challenge. That's the KPMG sum. Number 22 is the DLA Piper transaction. And we say that that's for drafting the due diligence that was carried out by DLA. The next one is at 39. That's over at page 115. Now here there is a point in that it says that it's property valuation in 2012 and 2015. But
KPMG don't usually value properties, anyway.
it may be that they have a separate valuation department in Spain. Anyway, they're obviously with a multinational business of that nature. I mean, again, we say, why should JOP or in now COP pay for a pre-onward sale valuation of the assets? And then the final one that we seek to challenge is the CBRE over the period at 116. And we see here a CBRE valuation in 2012.
That's at 40.
At 40, yes. What the judge, sorry, I should have just explained. So, for example, at 39 and 40, he's already split these matters into two because he's apportioned them between Soto and Campo. But we say that as a matter of principle, that it's incorrect, that because the costs should be borne by MGI itself and shouldn't, and that's what 10.3 envisaged, that everyone's costs should lie where they fall, and therefore it's not a deductible cost. It's a very straightforward and point, and that's all I have to say about it, my lady. Ground 3, again, is contingent on the appellant's success. And here, whilst we're looking at this table, this concerns just one row of this table at page 119, and it's line row, I should say, 67A. And this is the MGI debt to Santander. Now this is dealt with at paragraph 251, Roman 4 of the judgment. And what the judge said there, again, in relation to 3.3, here he agrees with me that if clause 3.3 is to make any commercial sense in this context, the relevant costs have to be borne by MGI or one of the Valderrama companies during MGI's period of ownership. In particular, clause 3.3 cannot extend to costs or expenses which remained with the Valderrama companies and are assumed by a purchaser, Zagaleta, on the sale of the Soto shares. Those costs will be reflected in a reduction in the price of the Soto shares themselves, and to allow a deduction for them in the calculation of net profit would in economic terms allow them to be taken into account twice in the computation. And what we say there is that this was a debt, as at the 2015 SPA, that MGI owed to Santander. And we see that in the supplemental bundle. So we turn to that one now, please. The supplemental bundle at page 119.
What's this document? Oh, yes.
This is the
Got it.
2015 SPA, the sale to Zagaleta. What we say there is that the purchase price is set out at just over 20 million euro. See that at 4.1. And then if one turns to 8.2 at page 128, we say that Zagaleta assumed this debt. It says that taking over the debt, at the first paragraph of 8.2, purchaser shall take over the debt, and then it says, and that debt is just shy of 8.9 million euro, and it says taking over shall fully release the seller. The point there is that was a sum assumed by Zagaleta, and it cannot be deducted. It should not have been deducted when the judge carried out that process of deductions. We say that it is the price for obtaining the shares. We see this at page 78 of the supplemental bundle.
Sorry, I'm struggling with this. Have I misunderstood something? You saying they shouldn't be... Has he agreed with you at 251 sub 4?
So he's agreed with the principle
Right.
that at 67A he has deducted...
So there's nothing more in the body of the judgment.
No, that's
At
right.
2514 it looks as if he's agreeing with you,
That's
but
right.
then there's the deduction in the
right.
schedule.
That's right, Mike.
That's what you're complaining
That
about.
exactly. That's
Okay,
precisely
all right,
it.
okay.
So what I say is that actually those two don't fit together, because there shouldn't have been this deduction, because actually this was a debt that I say was assumed by Zagaleta upon the 2015 acquisition, and that debts that were assumed should not have been deducted.
So what are you saying was the total consideration paid by Zagaleta then? So the 20 million plus the 8 million? 8.8 million?
I say it's the 20 million is the consideration.
Right.
Well, why isn't it 28 million? I mean, it's an
Well,
it pays X.
yes, yeah,
And assumes
yes,
a liability of Y,
yes.
Effectively MGI is released from a
Yes,
liability for Y. So
That's right. I mean, when I say that it's expressed as 20 million in the actual agreement itself, but in effect, it is the 28 million because they're assuming the 8 million debt.
But then the judge must have gone wrong in paragraph 142, mustn't he?
142 of the judgment.
Yes. So he said 141. He says the consideration is 20 million. 142. He says the purchase price was to be paid. 1 to 3 add up to about 11 million, and then 4 is the 9 million that we're talking about now. So that's judge is treating the discharge of the debt as being part of the 20 million purchase price.
Yes, he is. When I say as a matter of principle, he's agreed with me that any debt that is assumed by Zagaleta should not be deducted, and yet has gone on and actually carried out that deduction.
But what he's in fact done is reflected paragraph 4.2 of at page 119 in the supplementary bundle, where that breakdown of the 20 million is actually given in the same way.
Yes, I do accept that.
So sorry. So the actual you were right. You previously said so. It is 20. The 8 is treated as part of the 20.
Yes.
By everybody.
Yes.
So in fact, the consideration was 20,
Because
including
I think the consideration was 20.
A debt of 8.
And on that basis, you say you can't have it deducted.
And I say that it still should not have been deducted because we've effectively, what's actually happened is that if one turns to page 78 of the supplemental bundle, this is the 2012. Consideration is set out in paragraph 1.2. What we say is that essentially we have transferred the shares in Soto and Campo in return for MGI taking on debt, and that debt is then taken on subsequently by Zagaleta, and that debt remained. And in effect, again, this would be MGI seeking to obtain €8 million back of the consideration upon the exit, which would be an impermissible deduction. Again, it's a very neat and small point. Unless there are any other questions, those are my submissions on the remaining parts of the appeal.
But your actual objection is simply that the judge found in your favour at 251 sub 4,
but didn't apply it.
But did the opposite in the schedule.
That is absolutely it, my lord. Yes.
There's nothing wrong with his reasoning. He's
No.
just, when he's been at the end of this very long judgment,
Yes.
everything else, just made a mistake in deducting.
That's what we said.
That's what you say.
Yes.
Because you don't disagree with anything.
I don't disagree.
251
Not in the
sub
body
4.
of the. It's slightly different in terms of ground 2, where I actually do attack the reasoning and the width that he's given to deductions of 3.4.
Yeah.
It's a slightly different
Okay.
slightly different point. Are there any other questions, my lady, my lords?
No, thank you, Mr.
Thank you
Baker.
very much.
My lady, my lords, can I deal first with ground 3? I submit there's a fundamental error in my learned friend's submissions, and it is this. The question is, from what should the deductions be made? Now, my learned friend's case is that the price was 20.6 million. Fair enough. But of that price, 8 million was simply taking on the indebtedness. So if you ask what price did we receive without that indebtedness, it's 12 million.
Well, why? Hang on. Why? I mean, because you get the benefit of effectively being indemnified or released from liability. That's as good value to you as being paid cash.
It is, but this is. But we started off with this liability in the first place. The point. Well, but
that's your choice.
Well, no. Of course, I agree with that, my lord. But we start off with a liability of 8.8 million. That's a liability we've assumed under the 2012 agreement.
Yeah.
That's stage 1.
Yeah.
That, therefore, is a financing liability on the face of it, which we're entitled to deduct. That's stage 2, on the face of it.
On the face of what?
Under clause 3.3, because that's a debt we assumed under the 2012 agreement. And what clause, if I may forget for the moment, just leave on one side the Zagaletta purchase price. Leave that on one side. The question is, first question is, what liabilities did we take on in the first place under the 2012 agreement?
This is in order to acquire the shares.
In order to acquire the shares. And that 8.8 million was undoubtedly a liability we took on under the original agreement. There's no issue about that.
Right.
So, and that we say, on the face of it, that constitutes a financing liability within 3.3.
Oh, sorry, wait a minute. It's a liability to whom?
It was it's a liability originally, I think, from Mr. Ortiz-Patino to one of the banks.
Right. Okay.
And then we take on that liability.
You stand in his shoes,
We
and that's
stand
part
in
of the
his shoes
20.
in relation to that.
And he took on, he borrowed money from the bank for his personal business.
Yes.
So he just said when he sold you the share, or when you bought the shares, you just agreed to take on that liability.
That's right.
As part of the consideration that you paid for the shares.
That's right.
Okay.
We take on the liability. But our point was, and the judge agreed with this, that was a financing cost which we had taken on, which we're entitled, which on the face of it would be entitled to deduction under clause 3.3. Perhaps I could just go to clause 3.3. So 3.3.1, if you treat real estate assets including SOTO, we're entitled to deductions in relation to bank facilities or other financing secured on such real estate asset, in other words, SOTO, whether it's secured or otherwise. So we say, and as I understand the judge accepts, that on the face of it, this 8.8 million, or whatever the figure is a liability which we're entitled to deduct. On the face of it. On the face of it. It falls within that definition. That's stage 1. And I submit the judge has obviously accepted that because he's given the deduction. He's obviously accepted this is, properly speaking, a deduction we're entitled to make in principle. Because otherwise he wouldn't have allowed it at all. And it is an assumed debt. And he has said, I think in his reasoning, we are entitled to deduct financing costs and so forth. And this was a financing cost. So that's stage 1.
Was it a financing cost? Go on.
I mean, part of the difference, this is the artificiality of the whole exercise.
And
But that's a different point.
And when you say he accepted it, that's at 254, is it?
I believe, my lord, that's right.
And also in the schedule, 67A,
Yes.
by reference to 3.3.1, isn't it?
So, my lord, forgive me, can I just dig up page 254? Sorry, paragraph 254 of the judgment. So the starting point is that this was a sum of money and I submit this part of the findings is challengeable. This was a sum of money which, on a broad construction of 3.31, was a financing cost. So that's the starting point. So it is prima facie something which we're entitled to have deducted from the net price, or from the price, on an onward sale, on the face of it. And that's 254. So that's the starting point. We're entitled to a deduction on the face of it. Now, the question then arises, what happened on the onward sale? Now, I would accept that if on the onward sale we had received, let's say, cash of 20 million plus a taking on of the 8 million in addition, one would say that the total consideration we received was 28 million. But what in fact happened was there was a price of 20 million, 8.8 of which was this debt. So what did we actually get, as it were, under the agreement was 12.2 million, or whatever, plus 8.8. The question then arises, when you're looking at deductions, how do you work out the price? Do you say, well, you start off with a price effectively of 12.2 million, or do you start off with, do you say, and what we say is this, it's obvious that the price must be, well, rather, the benefit we've obtained under the agreement is simply a total of 20 million, including 8.8 being assumed. So the 8.8 has already been taken into account in the purchase price we receive. And so when you're working out the starting point for the sum, when you're working out what to be actually received, it's 12.2 million, plus the taking on of the 8.8 million debt.
Was this debt was secured on the shares, was it?
I think it was secured on the shares, yes. But there's no double counting. We're simply, and the point that's being taken against us is there's double counting. If you make a deduction for the 8.8 million, I would accept there was double counting if the purchase price was 20.8 million plus
28.
taking on with the 8. But what actually happened is the purchase price of 20.8 itself includes the 8.8. So there's no double counting when we say we want to have the 8.8 million as a deduction against 20 million. So the starting point for the purchase, so in other words, the judge was right to treat this as a deduction because A, it had been assumed, it was constituted an assumed liability within 3.3 in the first place, and B, the purchase price was reduced pro tanto by that 8.8 million. So actually all we got was not 20 plus, but we got 20 including the 8. And suppose for the sake of example, there was an assumed liability of 20 million in the first place. And then suppose also that what had happened is Zagaleta, the purchase price paid by Zagaleta was 20 million. But that was entirely taking on the debt we'd assumed. There's been no profit from that. All that one would simply say is, well, we assumed a liability of 20 million in the first place. When we sold on to Zagaleta, they just took that liability over for us. But to say that there's a profit in any of that, you'd just say, well, we landed up getting back to neutral. I'm not explaining it very well, my lady, but I think you have the point.
I understand.
That's why I say the question is, what is this to be a deduction from? If this was to be this is a deduction from the 20 million purchase price. And that's because we did not get reimbursed the 8.8 million in addition to the purchase price. It was all part of the purchase price. And that's where my learned friend's argument goes wrong. And that's why the judge has made the deduction. Just if I may for a moment stay in, I think, the supplemental bundle, I can deal with the ground 2 briefly, I hope. First of all, I submit
So you in fact say ground 3, just to be sorry to be clear, you say that 251 sub 4 is not actually dealing with this financing cost at all.
No.
It's dealing with other costs or expenses which the companies themselves, he refers to the Valderrama companies, which I think means the Besser and Balsa, is that right?
Yes, I think what it must do, I think, in this context.
So you say anyway, the specific dealing with this in the judgment is at 254, not 251 sub 4, and that's,
No.
and therefore you say it's consistent with that he is referring to 3.3. Yeah, I get you. Okay.
My short point is there's no double counting. The attack on the judge's judgment is amounts to double counting. There would have been double counting had it been 20 million plus 8, but in fact it was 20 million including the 8, so there's no double counting at all. Just on ground 2, very briefly, the judge said he interpreted clause 10.3 of the SPA as covering immediate costs of the transaction. In my submission, that must be right. And if one goes to 10.3, I think it's at 92 of the supplemental bundle. In reality, what 10.3a is covering is costs. All fees and expenses incurred in connection with this agreement and transaction should be borne by the party incurring such fees. That would be talking, for instance, about the legal fees of drawing up the documents and things. It wouldn't need to be said that your due diligence fees would have to be, or valuation fees would have to be borne by each party, but that would go without saying. It's just saying the actual transaction fees and expenses incurred in connection with the agreement, the immediate fees and expenses. That's my first point. But there's a second point, which is simpler, which is this, that when you turn to page 6,
Page 6 of.
the supplemental bundle,
Uh-huh.
3.3.4,
Mm-hmm.
3.3, for the purpose of clause 3.2, net profit attributable to a sold real estate asset, so you have to read that as meaning attributable to SOTO when it is sold, shall be calculated by reference in the following way. Then 3.3.3, by deducting the following, that is, any legal, accounting, or other professional fees incurred in connection with SOTO. Now, I submit with respect, that must cover, on the face of it, any legal, accounting, or other professional fees incurred in connection with SOTO, no matter when. And it does make sense.
What, even when MGI did not own SOTO?
Because it was, I agree, my lord, because it's incurred in connection with. It's incurred in connection with SOTO. That is, say,
This
in
is
connection.
right. So this is 2514.
Yes. Yes.
And you say the judge was wrong in 25140.
Well, not quite, because he is not here turning to the costs of acquisition. He's here talking about, let's say, MGI incurred lots of financing costs in the period, or put money in the period of its ownership. He's talking here about what happened in the period of ownership.
Do you say 3.3.4 is so broad that it would cover illegal accounting or professional fees incurred by MGI in connection with the relevant real estate asset before they acquired them, before what the SOTO shares were acquired?
Yes, I am saying that. And the reason I'm saying that is because this is a profit share. In other words, if you're trying to work out what the profit, the net profit I made in relation to this transaction, it is only right and fair that you take into account my purchase costs. And that makes sense if you're working out a profit share. But I agree all this is on a slightly unreal premise, we say. That's different.
So you're saying 251 little 4 actually doesn't go to the heart of this issue at all.
He's talking about something else.
Yeah.
He's not actually talking about, and indeed, well, it has to be fair for a judge. He has made a finding which, if one reads 2514 in a certain way, is inconsistent with it. But in my submission, 2514 is not talking about this. And if one asks, as a matter of logic, is it fair and just that on a profit share agreement, my costs of acquisition should be taken into account in working out the net profit I've made on a particular transaction? I submit, why not? I've incurred these costs in buying it. If you're trying to work out my net profit in relation to this or in connection with this asset, you take them into account. And that, on the face of it, is what, well, I say on the face of it, is what 3.3.4 provides for. Any, does say any legal, accounting or other professional fees incurred in connection with. That is very broad wording.
And so you say it's not 251 Roman 4, but it is 254?
Well,
No.
that's regarding financing costs.
Exactly. So there is not a paragraph which goes to this?
Well, I'm
It
not
just
sure there
appears
is.
in the schedule?
I think part of the problem, I think, if I may be fair to my own, well, I may say, I think these particular costs were bundled together with all the other costs, and so there was no distinction drawn between them below. The distinction was made for the first time. I take no point in this appeal, but that may explain why the judge hasn't focused specifically on these costs, because my learned friend's argument went rather further in relation to costs that couldn't be deducted than he's now running by virtue of clause 10.3. But in any event, my lady, I submit whatever the judge has said is not the question now. The question is now before you, and the question is, are due diligence fees, so forth, incurred in connection with the acquisition of Soto?
And these were not, you were not reimbursed for these costs, or there was no assumption of liability for these costs by Zagaleta?
No, oh no.
So you'd say in the same way as if, let's say, Vesser had acquired a real estate asset, an actual piece of land, a plot, which it obviously it had, and then sold the plot, in calculating the profit share in relation to that acquisition and sale of a plot of land, you would take into account, I deduct from the net price paid by the third party any costs which Vesser had
Incurred in
connection with its acquisition of the real estate asset way back when, or whenever it was.
Yes.
Way back when.
Way back when, if so be, yes. But I do say, in particular, in this context, even if my lord, you think that doesn't sound quite right in relation to Vesser, I do submit in this context, if you're going to expand these clauses to include sales of shares, if you're going to do that, there's no reason not also at the same time to say, well, we're entitled to a deduction in relation to any acquisition costs MGI incurred in connection with the acquisition of it. Again, all this does is highlight the difficulty, but that's a different point. And I just say on the wording, that's wide enough. It's simple as that. And it's not unjust, not unfair. In fact, what one might expect. So that's what I say.
Thank you. Mr. Blaker?
Very briefly, on that point, firstly, I do say that it's wrong that effectively what MGI is claiming, one example was DLA's actual legal costs of the transaction. So when Mr. Knox says that the costs of the actual acquisition, those legal costs, would be borne by the party that actually bears those particular costs, that doesn't appear to be what the judge has actually done, because he's actually made a deduction for the DLA costs, and it actually says in the table that it's the cost of the transaction. And I do say that there is this tension between 10.3, which in my submission does reflect that the costs should be borne by the party in acquiring the shares, that they will actually pay for those costs, and that it would be that it can't be right that my client should end up having to bear the costs of due diligence, of valuation, in this case, that MGI carried out leading up to the acquisition. I entirely accept that any costs, once those have been acquired, the assets are acquired or the shares acquired, whatever it is, then under the PSA, those costs will be borne, are a permissible deduction, so long as they're reasonable. But to actually end up paying for the costs that were incurred leading up to the acquisition effectively gives that money back. Now, Mr. Knox says, well, that's all because this is a profit share agreement, but that doesn't provide an answer to 10.3. And Mr. Knox, in my submission, really glosses over the fact that 10.3 is there, which does envisage the parties bearing their own costs.
I mean, is it inconsistent to say in the purchase agreement, the 2015 purchase agreement, the parties bear their own costs? That's to do with the sale of the shares to Zagaleta. Then, when you come to work out the profit, you ask, well, what costs and the relevant party, what has the vendor incurred in acquiring the shares? Why is it inconsistent to merely because 10.3 says they lie where they fall? And that means you've got to pay them, but it doesn't mean to say that they can't form part of a subsequent calculation of the profit, does it?
But my lord, I mean, let's imagine a scenario where a party, as happened here, a party takes a great deal of time to make a decision as to whether it wants to acquire the asset. And it carries out a series of valuations, and it goes off to a number of different surveying companies to carry that out. And because of the technicalities, they go off to a number of different lawyers on the corporate and the tax structure and all the issues that were dealt with here. In my submission, it wouldn't be right that they could bundle up all of those costs and then say, well, we can then just deduct them as a legitimate deduction under 3.3. Because
even though their profit is reduced by having made.
But that's a choice that they made. I mean, that's my point. They've taken, one purchaser may be more risk averse than another.
Okay.
But if Vesa, say, had to acquire a plot of land, done a investigation of title and all the other sort of things you would normally do before you buy a piece of land, and had paid money, you would accept that in calculating the profit which that company made when selling that plot of land for the purposes of your profit sharing agreement could deduct the costs which it had chosen to spend.
I would accept that.
You would accept that?
Yes.
So, on the assumption that we're in your favour and reading this now to relate to the Soto shares, the acquisition of the Soto shares by MGI, when you come to look at the share purchase agreement under which MGI acquires the Soto shares, everybody agrees at that stage the costs lie where they fall. In other words, the person who's incurred them has to pay them. But why is it inconsistent with that earlier agreement, then say, but when you were doing something different and calculating a profit share of MGI on sale of those shares, that it should take into account the costs which it incurred in relation to acquisition.
Well,
it's a profit share.
Yes,
That's the point that's made against you.
It is a profit share, but what I say there is that there has to be a starting point for that, and that's that date of it's the date of acquisition in 2012, and it's what added value that MGI was going to be able to generate, either the land itself or the shares, and upon selling it, and that.
But it just, I mean, if all the share purchase, all the 2012 share purchase agreement was saying, as between the parties of this agreement, who bears the costs of in relation to this agreement, the transaction, this agreement by which MGI bears the shares. It didn't say, and it can never, seek to recoup itself, or have those taken into account in some other way. So when you have a subsequent agreement, why do you assume that those couldn't be taken into account when calculating profit? It doesn't say you can't.
No, it doesn't. It doesn't say that. Because I still maintain my submission that 10.3 envisages, whilst it envisages the parties actually paying the invoice that's proffered and that they have to pay at that time, that there's implicit in that the idea that is a cost that will be ultimately borne by that party, and one that won't be deducted, and that there's a starting point.
And won't be deducted in any future discussions in relation to profit share. It doesn't say anything.
Well, they're entering, of course, that in on the same day, but that there's effectively a starting point with the profit share, and the idea of the profit share is it's now over to MGI to generate profits from this land or from Soto and Campo or the Spanish companies. On ground.
If you wanted to do that, you should have said should be borne and shall not be. There was no attempt to read across from the SBA to the profit share to do what you say effectively it was doing, which is to say shall be borne and shall not form any part of the deductions for the purposes of the profit share under the agreement which we're signing on the same day.
Yes. I mean,
yet you're saying that's the implicit. You're saying that's implicit in the words "born by."
I mean, well, yes, my lord. I mean, what if a company, if a purchaser came along and then a year in advance of back in say 2011 carries out some form of legal or accounting or tax investigations or valuation, they then walk away for a year or so and then come back. I mean, it wouldn't, in my submission, what the judge would effectively be allowing here would be a benefit for them carrying out their investigations as to whether they wanted to purchase the assets, and that.
In the same way that Vesa would be entitled, it would be deducted if Vesa had decided to carry out such investigations in acquiring the relevant asset. You accepted that?
Which I did accept. Anyway, I'll deal with ground 3, my lord. Ground 3, Mr. Knox, again, just only one point really in response at 254. I just say that if one turns over to page 102, it's the second part of 254, there the judge has, when discussing the financing costs, he makes the exception in the middle of that remaining part of the paragraph that unless the costs are assumed by Zagaleta under the 2015 SPA, and suggesting there that they would not be deducted in that scenario. I say that ties in with the 251 Roman 4. unless there are any other matters, those are all the submissions and matters on the appeal.
Thank you very much,
Thank
Mr.
you.
Blaker. And on that basis, I think we can now move on to the respondent's notice.
I'm grateful, my lady. My lady, I'm going to deal with grounds 1 and 2 first.
I'm sorry, Mr. Knox, I've just thrown my pen on the floor. Be a moment.
I'm not sure that's a good omen or a bad one.
No, just dropped from my hand. Thank you. There we go.
I'm going to deal with grounds 1 and 2 first, and then ground 3. And when I'm dealing with grounds 1 and 2, I'm just going to, first of all, just very briefly introduce what the point is in the case. I will then summarise the issues which arise on both grounds 1 and 2, so you can see where I'm then going later. Then I shall first deal with ground 2, because in my submission it's unanswerable and it's the much simpler of the 2 grounds. And then I'll deal with ground 1 briefly. Now, just a couple of preliminary points. Obviously, the respondent's notice arises only if the appellant's appeal succeeds, and we seek a set-off against the appellant's claim under clause 8.1 profit share agreement for breaches of warranty or misrepresentation by the appellant under the 2012 SPA. And there are 2 relevant breaches. One is the non-disclosure, can pose contingent or prospective liability to pay a fee in relation to the grant of an interest turístico to the town of Castellar de la Frontera, which after the 2012 SPA was eventually assessed, the liability after the SPA was eventually assessed in the sum of about 1.42 million. The second breach is non-disclosure of various debts owed to professionals and by way of VAT, and I think some other local taxes, which totalled about 1.24 million euros. I'll come to the relevant clauses later. The important point to note for the moment is either breach would extinguish any liability to the appellant, at least on the judge's current findings, which would have allowed for a profit share of 803,925.65 euros. So if you work out the current profit share on the judge's current findings, ignoring grounds 2 and 3 today, that is what the sum comes to. And we set out our calculation of that in paragraph 38 of our replacement skeleton at page 302 of the core bundle.
But the judge didn't make any findings about these matters, did he?
Well, he did. He did. He says in case the matter goes any further, and
Yeah.
he did make some findings
Some.
subject to Swiss law.
Yeah.
Now, I'll come to that in a moment.
Okay.
My point is, he could only be making those findings. First of all, they're plainly right. But secondly, the only purpose of his making those findings was precisely so that if this matter comes to you, you can then decide whether we are right, in particular on the Swiss law issue. And really what he said in my submission was, I agree with Mr. Knox on these 2 claims. In principle, I agree with the figures and so forth, but I don't know what, I'm not going to make any ruling on Swiss law. Just for the pleadings, if I may, can I just ask you to see how the pleadings were put? And first of all, the core bundle at page 143. One can pick it up. This is our amended defence. But in 143, it's subparagraph 4b, we essentially set out in rather general terms an entitlement, or rather loss, suffered because of misrepresentations and non-disclosures. So it's 143, subparagraph 4b, but the really important paragraph is subparagraph 4a later. But 4b simply sets the scene.
So 4 little b and then
4
4
little
capital
b.
A.
4 big A, yes. But it's really 4A. But 4B is the original allegation. But then 4A, you can see, perhaps I can just take it from there for the moment. The claimant sought further information in respect of these misrepresentations, which for convenience, the defendants attached in an appendix to this offence. You can see these entitled set off losses caused by these misrepresentations by virtue of clause 8.1, the PSA, because they amount to breaches of the 2012 SPA, so forth, and the losses claimed are genuine estimates for the breaches, and in any event, they're correct. And then one goes to the amended, the appendix. It begins at page 157. Well, I don't need to take you to all the misrepresentations, because the only one that is now relevant is the sixth misrepresentation, which one finds at page 164. I don't know, my lady, my lords, if you've had a chance to read this, but essentially we say there are two relevant clauses in the 2012 SPA, 3.8A9 and 4.8A9, by which promises are made that all relevant liabilities, contingent or otherwise, have been disclosed in the disclosure letter. Right, that's the summary of it. And then we say, I'll come to those clauses later, we say, paragraph 38, these representations were untrue and JOP was a breach of warranty because, then you'll see what we say, these are the statements, that is to say, the relevant disclosure letter statements, or any others showed liabilities to pay, liability of 3.27 million, eventually settled at 1.4 million to Castellar. And then you can ignore the rest of that, paragraph 1. And then secondly, neither these statements nor any others showed liabilities to pay debts owed to the government. And 3, because neither these statements nor any others showed liabilities to pay debts incurred for Job's benefit, referred to in paragraph 37.1 of the defence, that is Swiss francs 100,000 owed to Mr. Galantes and 127,000 euros owed to Mr. Murray. And because neither these statements nor any others showed these companies liable to pay IBIS taxes and so forth, outstanding charges. Now those figures were subsequently particularised. But that's the long and short of it.
And where's the interest touristico in all that?
It's there, my lord. I think it's right at the beginning, subparagraph 1. It doesn't call it an interest touristico. Okay. A liability to pay essentially 1.4 million as settled to Castellar. I think it's previously been described in a different part of this document. So there's no issue about that. So that is the interest touristico. So that's the allegation. The effect of the reply to that, I should say further information to very similar effect on the sixth misrepresentation is provided at page 210 of this bundle. I don't propose to take you to it because it's simply further information. The reply to the allegation is set out at page 174, paragraph 28b. Paragraph 28a does deal with 23.4a, but it doesn't, not in any material respect now. As to but 28b, as to the remainder of 23.4a, the alleged misrepresentations have no relevance to this claim, and the claimant does not intend to respond to substantive matters upon which the court will not have to reach any determination. Then, next point taken, the allegations are not a defence of this claim and should have been brought in the courts in Geneva, statute barred, and would have been governed by Swiss law. They go on to say this is the first time you've made this allegation. And they also then go on to say that the relevant date in clause 8 of the profit share agreement would have been December 2015. And any relevant claim, I'll come to this in a moment, any relevant claim under the PSA would have had to have been made before the relevant date. So too late, in other words, to make the claim on a matter of construction of the contract. No such claim was made before the relevant date, and indeed no formulated claim has been made since then. So they say you're too late on the proper construction of clause 8A, and then they go on to say also sums are estimates, and they dispute the losses. So essentially, irrelevant, statute barred, and claim made too late, even if not statute barred, on the proper construction of the contract. Those are the points they raise. Now, if I can just ask you first to look at the clauses on which we say were breached and which we say the judge accepted, certainly appears to have accepted, were breached, subject to the Swiss law point. And that's in the supplemental bundle at page 85, tab 3, I think. 3.1a, and my lords, could you note the heading on this, because it simply gives you, as a useful heading, representations of the seller relating to Holdco, that's Soto, and Campo. So these representations relate to Soto and Campo, not the underlying companies. And then 3.1a, except as general principle, except as fully and fairly disclosed in the seller's disclosure letter, the seller provides the representation set out in this section 2.5, obvious mistake, for the purchaser as of the effective date and as of the closing date. And then you turn over, and we've only extracted the relevant parts of the SPA, so it goes on for a long time. Page 86, 3.8, absence of changes. A, except as disclosed in the seller's disclosure letter or as otherwise contemplated or permitted by this agreement since 31st December and through the date hereof, then you have a whole series of representations. But the important one is over the page, 87, subpara 9, Roman 9. Neither Holdco, neither Soto nor Campo Alto has incurred any liability. I emphasise these words, whether prospective, contingent or otherwise, and whether arising on or after closing, including but not limited to any liability to any advisor, agent or other person which was not settled prior to closing by the seller. So that's the first of the representations, which we say was broken by virtue of the non-disclosures I've summarised above. And then page 88, one moves to clause 4, and you'll see the heading here at the foot of the page, representations of the seller relating to Valderrama Estates and Valderrama 07. Valderrama is what we call Valsa, and Valderrama Estates, I think, is Essa. And Valderrama 07 is V07. Then you have, I think, identical form of wording, except as fully and fairly disclosed and so forth, the seller hereby represents to the purchaser, and so on. Then you have a similar structure. So page 89, you go to 4.8, absence of changes. And then over the page, page 90, subparagraph 9, neither Valderrama, Valsa, Vessa, nor V07 has incurred any liability, whether prospective contingent. So identical wording. So we say whichever of the companies had these liabilities doesn't really matter, because these representations cover liabilities both at the holding company level and the subsidiary level. We say these representations were breached. Now, if I can go to the judge's judgment on this point at page 106. Page 200, para 273. And the context of this is it begins at page 103, para 264. This is where he's dealing with the misrepresentation breach of warranty claims, and this is what he says at para 273. I have decided this case on the basis of MGI's arguments in relation to the extent of clause 3 and 4 of the PSA. I do not need to determine these questions in order to determine this case. I do not do so. In case this matter proceeds further, I have set out below some comments on the evidence in relation to the various claims raised by MGI and the parties' arguments on them. And I respectfully submit he is plainly envisaging that this matter might go to the Court of Appeal, and if it goes to the Court of Appeal, we might want to deal with this point. And so I do submit it as properly before you, but I do submit the findings of fact which he makes, unless my learned friend can show that wrong, are findings which you should adopt. Because he does make, and this is the point I make, he makes sufficient findings for the purpose of my claim that there were breaches of these relevant warranties. And indeed, there's no basis for saying they were wrong. I mean, they're quite obviously right. you'll see, well, you will have seen how he deals with the point in relation to my current claim, the way I put it, page 110, 294, financial liabilities. Well, perhaps it starts at 109, the interest heuristica, because this, in fact, is all part of the sixth misrepresentation. But he deals with this at paras 288, 293. And can I just ask you to note in particular, there is no dispute, however, 293, there is no dispute, however, that a contingent liability had arisen. The most relevant provision for MGI's claim for a set-off is clause 4.89 as a prospective or contingent liability, subject to matters of Swiss law, where I've referred, I would agree with Mr. Knox, it's no defence to the claim that potential liability was recorded in publicly available documents. However, the claim is subject to Swiss law issues which I've referred to above. And in the previous paragraphs, he sets out his findings. As I say,
is his comment that it's no defence that potential liability was recorded in publicly available documents to say that it should have been, to breach a warranty claim, it should have been subject to specific disclosures under the agreement? That's the context of that.
That's the context. What was said against us is, oh, well, you could have seen this by looking at the public records. Which we said, well, we didn't. And we say that's irrelevant given the nature of the warranty.
Yes, actually, it's 291. Sorry, he's yes, I can see that at 291.
And we also rely, of course, this is an English law point, but it's a slightly different point on Redgrave and her. But the basic point is it's irrelevant, even under the terms of the documents. And then financial liabilities, which is ground 2, but which I proposed.
Just out of interest, how do we know that?
Sorry?
How do we know that? That it's relevant to, that it's recorded in publicly available documents? Why do we know that? Because this is a Swiss law document.
Well, no,
the SPA,
yes,
that it's said to be a breach of warranty of not to disclose is governed by Swiss law.
Yes.
So how do your if it was governed by English law, you may be right, referring to in what you say in 291, but it's a Swiss law governed document. How do we know that under Swiss law, the fact that it's referred to in publicly available documents doesn't make a difference?
There are two issues, my lord. One would be the Redgrave and her point, which I would accept. You can't necessarily assume a Swiss law would follow. That's different. But I do submit, but I will be coming to this later if I may, I do submit that one just looks, as a matter of English law and a proper construction of the documents, there is no reason to say that publicly available information which is not disclosed, as a matter of English law, one would say, well, it's irrelevant. Yeah. Now, the question then would be, does the presumption of similarity apply in Swiss law? And I will be arguing this later, but I say it would, because it's absolutely plain what the construction of the contract should be. But, my lord, that is a point, if I may, develop later.
Yes, although it's not really a question of construction of the... Is it really a question of construction of the document?
Well, except as disclosed, there are no liabilities. That will be my submission, my lord.
Okay, all right.
Can I deal with that, if I may, in due course? I'm sorry to... I don't want to sound as I'm blocking.
No, I just want to identify where Swiss law came in, because the way you very smoothly presented it, it was, as if we hadn't even touched Swiss law.
Oh, no. No. But I will be dealing with the presumption of similarity in a moment. And of course, the judge himself doesn't deal with it. That's the point. Yeah. But this is the first... I'm dealing at the moment with the facts as found by the judge.
Well, yeah, in fact, it's, as he said in 293, subject to the matters of Swiss law to which I've referred. That's what he means.
Yeah. Yes, exactly. Yes. I'm not saying he's decided Swiss law at all, but I'm simply at this point saying he has made sufficient findings of fact that there was a breach, and
hang on, but he hasn't. The point is, he said, subject to the matters of Swiss law, I would agree. But that's like saying, well, apart from that, Mrs. Lincoln, how was the play?
But he has maybe. But what he has done is he's found facts which give me the base for saying, if you can apply the presumption of similarity, then we win.
All right.
That is my point. And what I'm at the moment simply on is the question of facts that are found, as opposed to whether the presumption of similarity should apply.
Okay.
But I say the facts are found there in interest heuristica, and the sufficient facts are found in 294 and 295 in particular. He sets out what the other financial liabilities were in 294, and he adds that there was the liability to pay the interest heuristica in 294, and then 295, as with the claims for deductions in the computation of net profit I've addressed earlier, there was little or no evidence before the court to support some of the liabilities to which I referred, other than the various schedules. I would have been prepared to accept the liabilities to Mr. Galantis and Mr. Murray, and certain liabilities that fell within this category and are referred to in the 2015 SPA as being assumed by Zagato, that would form a valid basis for a claim for set-off. So there's the finding of fact. Those liabilities, and then he explains what those liabilities are. Then he says these claims are subject to the Swiss law issues to which I've referred. So again, I say the finding of fact has been made, which at least grounds the claim that, subject to the presumption of similarity, grounds the claim for a set-off in the amount of those undisclosed liabilities. So the real question is the question of Swiss law. But before I get there, I do just need to explain some other matters which are raised by my learned friend, and I hope a logical sequence. Now, I submit on both grounds the following issues arise, and I'm going to take them, I hope, what you might call logically the right way, bearing in mind the points my learned friend raises, intermittent in this defence. The first is Clause 8 of the PSA, and that gives rise to three questions. Does the English court have jurisdiction at all to decide the set-off arguments? As my learned friend says, on a proper view of Clause 8, the English court does not have that jurisdiction. Secondly, if the court does have jurisdiction, does it have, can it allow the claims based on the facts in grounds 1 and 2 to be advanced, even though they were raised only after the Zagaleta SPA that gave rise to the profit share? My learned friend says we had to raise them beforehand. The next question raised by my learned friend is, are the claims we're making in any event statute barred? Because the first time they were intimated was in the amended defence in January 2022. Those are the 3 points, essentially, my learned friend raises as a matter of principle on Clause 8. The second issue is this. If the claims which I make...
Is that statute barred as a matter of English law or Swiss law?
Well, he says Swiss law, which we say, no, they definitely aren't. That's a different point. But those are the 3 questions on Clause 8 itself. In other words, preliminary points. Second issue is, if the claims in grounds 1 and 2 do come within Clause 8, and I can pursue them, first of all, is there, as my learned friend appears to try to do, any basis for challenging the judge's findings of fact in the paragraphs I've shown you? And I hope I can deal with that briefly, but I do mention it as an issue. And the second, but related issue, I'm still on the second issue, is there a basis for saying, as my learned friend does, that he ought to have made other findings of fact which would affect my client's rights? In particular, that my clients should have realised on ground 1 that, in particular, my clients should have realised that there was the interest heuristica. That's one of the things my learned friend says. And should my clients have realised that there were certain other liabilities outstanding? He raises that as extra points. And we say there was no basis for saying the judge should have made other findings.
Was he invited to make those other findings?
I think broadly, yes, although they weren't in many respects, but in some respects, as I come to later, weren't pleaded. He was invited to make certain other findings. But the long and short of it is, I say, he was right not to make them, but in any event, it doesn't matter, even if he should have done. If I may, I'll explain that later, because they wouldn't make much difference when it comes down to it. The third issue is on the findings of fact actually made by the judge, just concentrating on the findings of fact made by the judge. Does my client have a good claim under English law for a set-off in the sums respectively, I think, of 1.2 million odd in relation to the 1.4 million in relation to the interest heuristica, and about 1.124 million in relation to the other financial liabilities.
That's a claim for set-off under Clause 8?
Yes, that's in other words, assuming I can go under Clause 8, do we have good claims for the moment, just taking it under English law, for damages in the sums we claim? 1.2 million, I think 1.4 million, about 1.24 million. Do we have, as a matter of English law? And then the next question is, on those findings, should the presumption of similarity apply? Should one assume that Swiss law would come to the same conclusion as English law on those claims? Then the fourth issue, in a sense, is a mere sub-issue of the third issue, but I call it a fourth issue. If, contrary to my case, the judge should have made further findings, as suggested by the appellant, how does that affect the claim? We say not at all. Partly he shouldn't have made the findings. There was no reason why he should have made the findings, but also, even if he had, they wouldn't provide any defence in English or Swiss law. So those are the four issues. If I can turn first of all to ground 2, that is to say the other financial liabilities than the interest jurisdico. Now,
there is one other issue floating around about whether you're entitled to do this without without permission. In other words, whether it's a cross appeal or whether it's.
My lord, not at that. My lord, no. That relates to my third ground. That is not a ground in relation to. That's not an objection in relation to the first two. And the reason I say that is because if we're right on this, we get exactly the same result by way of set-off. On the third ground, supposing I lose the first two grounds, the third ground only takes me so far and won't provide a complete set-off, so the order will have to change.
I see.
And that's the Trinity Logistics point. There is another case, which is referred to in the White Book, which considers Trinity Logistics, which basically makes the point that if all you're seeking to do is to get to the same order as before, then
right. So
that's, and that's what we're seeking to do by reference.
Point doesn't bite on the grounds we're considering at the moment.
Yeah, it doesn't bite on. And if I may anticipate, in relation to ground 3, I accept if grounds 1 and 2 are completely wrong, then I would need it because on its own it doesn't get me to a complete set-off. But what if I'm partly right on ground 2, let's say, so I get enough, but not quite enough, to satisfy the set-off. But then ground 3 comes in like a white knight and gets me off completely. So, but I'll come to that later. Can I deal first with the jurisdiction point? Clause 8, 8.1, the profit share arrangement, and that's at page 11 of the supplemental bundle. Can I just ask you to read 8.1? Well, my lady, my lords, it might be helpful if you just read the entirety of clause 8. This is all relevant. Perhaps 8.11 less so, but all of it is relevant. And one needs to see it all in the round. And the most relevant of these clauses is 8.1.2, which is not a case where we're bringing a settled claim. 8.1.2 deals with claims which have not been, quote, settled by the date of the entitlement to a profit share. Now, you'll see in 8.1.2 a reference to settled and settlement Now, settlement, for that purpose, you have to go to 8.3 to see what the clause is talking about. Claims shall be treated as settled for the purpose of this clause if drop and the purchaser shall so agree in writing, such written agreement not to be unreasonably upheld, or a court of competent jurisdiction. I just want to emphasise this. A court of competent jurisdiction has awarded judgment in respect of the claim, and no right of appeal lies. So what this appears to be envisaging is you have a process by which, where there is a claim which has not been settled, or we say made, what happens is we can deduct whatever it is, our claim, from the profit share as a genuine pre-estimate. But then the matter has to be determined by the court. And when the court determines it, it is, quote, settled. And you have to pay, if you deducted too little, you have to pay the difference. If you deducted too much, then you get a reimbursement. That's broadly the structure of it.
And the relevant date, for the purposes of this, on the assumption that the sale of the Soto shares to Zagaleta triggered the clause, is when?
My lord, one has to go back to 8.1 for that. Sorry, the top, on page 11. Notwithstanding the purchaser's right to deduct amounts payable pursuant to clause 6.2 in the event that before any date on which the amounts payable
That's what I'm asking.
comes due, the relevant date.
Yes, but I'm asking you what that is. Is it it's sometime after the 30th of November 2015, presumably? Because the relevant date is the amount on which amounts are payable to JOP under this agreement. And under this agreement, the hypothesis of all this is that you've lost on the sale of the shares in Soto, giving rise to a profit share, correct?
Yes.
And the profit share under under clause 3 is paid 30 days of the receipt of the purchase price.
Yes.
So the SPA with Zagaleta is the 30th of November 2015, but when is completion due?
I'm not sure that's in evidence, but it was.
Well, I'm just looking at the agreement.
Yeah.
The agreement.
I'm not sure. It may even be completion, in fact.
Okay, so the price would be paid. I'm just trying to. Is that right? Closing date under the agreement. I mean, does it matter?
It may not matter.
Well, no, but I thought before we get into some timing questions, because there's going to be questions about timing.
Well, you're right, my lord, but from our point of view, it doesn't matter. The reason I say that is all we have to show, looking at 8.1, is that the facts which give rise to the claim arose before the relevant date. That is to say, they arose before the 30th of November 2015. And the facts which we complain about undoubtedly did arise before the 30th of November.
Well, let's just take it, not worry about exactly when completion was. Let's assume, if you're happy to do so, it's the 30th of November 2015.
I think it's common ground that all the breaches of warranty, I mean, if there were and so on and so forth, took place. All the non-disclosures, in fact, took place back in 2012 at the date of the execution of the SPA.
Okay.
Now, the first question my learned friend raises is this, because we're complaining about a breach of the SPA, which is governed by Swiss law, it follows that we have to bring any claim for a breach of the SPA in Switzerland, and the English court has no jurisdiction to deal with this matter, notwithstanding what is said in Clause 8, at all. We just can't bring this claim in England. That's what my learned friend says. Now, my short answer to that is Clause 16. Page 13. This agreement shall be governed and construed in accordance with the laws of England. Parties irrevocably agree that the courts of England shall have exclusive jurisdiction to settle any dispute which may arise out of or in connection. We say that's it.
You say you can determine the English court can determine any question set off under Clause 8.
Yeah. And we say also there's no provision in any of this in the PSA that provides that the question of set-off must first be determined by the Spanish court.
Swiss.
Swiss court. And the premise of the clause, in my submission, is this, that the Swiss court has not already determined the set-off. And hence, if you look at 8.1.2, it provides my client can make a genuine pre-estimate where the claim has not been settled. So the premise of that is that there is a claim that's not been settled, in which case we can make a genuine pre-estimate. So this is not a matter where the Swiss court has already to have decided the matter. And also, it provides in 8.1.2 for further adjustments if the genuine pre-estimate turns out to be wrong, once there's been, quote, a settlement. And I come back now again to 8.3. Claims shall be treated as settled for the purpose of this clause if, and then important, as I took for a moment ago, 8.3.2, a court of competent jurisdiction has awarded judgment. No, it doesn't say the Swiss court has awarded judgment or will award a judgment. I submit this is quite clear. There's no exclusive jurisdiction for the Swiss court in relation to a claim for set-offs. Otherwise, 8.3.2 is completely misleading.
You're rather rolling up in that phrase you've just used, claim for set-offs, the two stages of the process. The first thing you need before you can even think about having a set-off is having a claim.
I do, yes, I present.
And the claim arises not under this document, but under the sale and purchase.
It does, which itself has an exclusive jurisdiction clause.
In favour of
The question then arises, what is the overall intention of this document executed at the same time? And in my submission, it is that the English court has jurisdiction in relation to a claim for set-off.
It's a sort of retention provision,
Yeah.
subject to resolution of a dispute by whichever court is properly, either by agreement or whichever court is properly seized of the dispute.
But the English, my short answer is, looking at clause 16, which provides that any dispute, exclusive jurisdiction, the English courts have, English and Welsh courts have exclusive jurisdiction to settle any dispute which may arise out of. But in my submission, that must mean if there is a dispute as to whether or not I'm entitled to a set-off by reason of certain facts, then it's for the English court to decide that.
But the question of whether you're entitled to assert a claim, for example, under a document governed by Swiss law, would be determined by, you'd say, this court,
yes.
But it might have to apply Swiss law to find out whether you're entitled to subject.
I accept that. There's no issue on that. I'm not saying English law therefore applies also to the construction of the Swiss document.
No,
I'm simply
the
saying
question of your entitlement may have to be governed by another law.
and I accept that. But I'm just on jurisdiction.
Yeah.
So I say the English court has jurisdiction. The next question is, do our claims come within the clause, or are they just too late? My learned friend says they're too late. And I say, no, they're not too late. And the reason I say that, I go back to 8.1, notwithstanding our right to deduct sums under 6.2, in the event that before any date on which the amounts are payable to job, so in other words, under this agreement, profit share consideration becomes due, that is to say, 30th November, the purchaser shall have become entitled to assert against job any claim for breach of any provision of the acquisition documents. The following provisions apply. And I submit that these words are very wide. The purchaser shall have become entitled to assert against job any claim for breach of any provision.
Right, but that must mean shall have become entitled and remains entitled. I mean, if you've become statute barred, for example, under whichever local law, then why do you say that you would, the fact you had a claim, you've allowed it to become statute barred in the relevant jurisdiction? I mean, why do you say, is that a relevant point?
No, well, my lord, I say two things. My primary position is this is a set-off, contractual set-off provision.
Correct.
And there's no reason in relation to set-offs why one should presume, certainly as a matter of English law, was intended that the limitation period should apply to set-offs. I mean, generally speaking.
Oh, I disagree. Depends what you mean by limitation.
Yes.
As a matter of English law, if your claim that you seek to set off has become by statute barred, it would be very unusual for you to be able to use it as a set-off. If you're saying, is there some limitation on the time within which you have to assert the set-off? Well, no. But the idea that you could actually set off a claim which has become statute barred is quite, that I wouldn't accept as a proposition.
My Lord, as I say, my primary position is these words are sufficient, but I take your Lordship's point. But my secondary position is it doesn't matter because they're not statute barred.
Right, okay.
But anyway, so we say these words are wide. I'm not here on the statute barred point. I'm just on my own slightly different point, namely is, regardless of statute barring, are my claims just too late because they were not made before the profit share consideration became payable. And essentially, as I understand it, what he's saying is on a proper construction, if we make a claim before the profit share consideration becomes payable, let's say before November 2015, then we're in. But if we make it only afterwards, then we're out.
Oh, okay.
And I say, no, that's wrong as a matter of construction.
Different point. Right, okay.
And nothing in this provision says we have to have made the claim before the 30th of November, if you take that as the relevant date for the moment. It's simply saying, all that's saying is all that we have to show is we became entitled to assert a claim before the relevant date. And we did, we say, because the breach had occurred before the relevant date.
What you mean is it says entitled to assert, but it doesn't also say and asserted.
And has already asserted.
Yes. At a
these
particular
words.
time.
Well, you say if it had wanted to do what Mr. Blaker says, and we'll obviously respect how he puts it, but it would have just said the purchaser shall have asserted against job any claim.
And we say that, first of all, it doesn't say that. Secondly, we say that would be no reason to read this provision as saying that.
No. As long as you have an extant cause of action, you say that's enough.
I might not have asserted it yet for any number of reasons. One is I might not have known about it. Second, I might not have wanted to rock the boat when I was, for whatever reason. Maybe all sorts of reasons why I would legitimately have not wanted to assert it. And also it's difficult to see what prejudice would have followed by my not asserting it in this context, because it's a pure profit share arrangement.
Yeah. Okay.
So that's what I say on the second point. I also, on the second point, rely on 8.2. On this point, nothing shall prejudice my right to make any claim either under this agreement or under any of the other acquisition documents, which again I submit presupposes that I can make the claim even afterwards.
Well, what it's probably trying to deal with is that you might be able to assert a set-off, but your claim actually might be worth more than the set-off.
Yes.
So what it's saying is you can set off
Now,
but if you're due any more,
go to Switzerland.
well, assert the claim in this case, whatever. Yeah.
But anyway, I say that's a short point. But the third point is my learned friend takes is on limitation. My Lord, I've made my first point, namely it's a contractual right, and limitation doesn't apply to it. But in any event, one asks, we're looking at the Swiss document, the 2012 SPA, that is governed by Swiss law.
Right, but limitation of what? Sorry, and I know.
Statute.
No, sorry. But is it limitation in relation to the underlying cause of action has become barred by the relevant law under which that claim has to be made? Or is it that you didn't assert the set-off by a certain date as a matter of English law? It's
No.
the former, isn't it?
I think it's the former, yes, undoubtedly. That's as I understand the point that's taken by my learned friend. Your claim, as a matter of Swiss law, was already barred under the 2012 SPA.
Yes,
You
so
hadn't
that...
made a claim.
So that when it's the point I put to you a few minutes ago, which I thought was live, that the purchaser shall have become entitled, and the question is whether you must still be entitled
Yes.
under whatever governing law to assert, such that if you become barred under the relevant governing law, you no longer have a valid claim to assert by
Well, my Lord, I've given my first answer. I say that's not right, but I don't want to go back into that. I say the words are wide enough not to cover that. All I need to show is I shall have become entitled to assert. It doesn't go on to say, and still is entitled to assert. That's my first point. And I say, as a matter of justice, there's no particular reason why I shouldn't be entitled still to assert. Let us say a statute-barred claim. That's my first point, as a matter of construction.
But generally, set-off is regarded, I mean, speaking as a matter of English law,
Yes.
set-off is regarded generally as, well, probably a bit controversial here, but it has substantive effect, but it's a procedural defence normally to a claim.
Yes.
And I say I will be corrected if I'm wrong, but as a matter of English law, I thought you couldn't assert a set-off of a statute-barred claim.
It all depends, I think, whether it's an equitable set-off or the type of set-off. Because you can have a set-off which gives rise to a defence, and then, as my understanding, but my lord, there are no authorities, my understanding is it certainly can. You can make what you might call a claim which on its own is statute-barred, but you bring it by way of defence, by way of equitable set-off, and that will you'll be allowed to do that. It's not always the case. It depends on what type of set-off one is talking about.
I suppose the logic is that you might have been sitting there thinking that you've got a countervailing claim, and therefore no need to stir things up. And then time goes past and the position shouldn't change.
Yes.
So you say as a matter of legal set-off, legal set-off is just one debt against another.
Mutual debts, as it were, yes.
And that does, I think, require there to be a non-statute barred debt. But you're
Yes,
saying
I
that
think that's
equitable set-off might operate differently.
In relation to building contracts, for instance, I think that sort of thing would happen. I've got an old claim, but I'm entitled to set it up as a defence to a claim for, let's say, non-payment of fees. But my lord, I don't think I can sort of say that there's a specific rule in English law which would necessarily affect this, save to say, I do say, as a matter of contractual interpretation, all we need to show is we shall have become entitled. That's it. This is a contractual right. We don't have to show it is that the limitation period in Switzerland hasn't gone by. That's my first point on limitation. It's wide. Shall have become entitled. The question is, have we become entitled? It doesn't say and still are entitled. And secondly, and I might add, in the context of a profit share arrangement, why should one read a limitation point into it? Because if you're trying to work out what profits I have actually made, in my submission one is entitled to take into account the fact, for instance, that I've lost a lot of money under the 2012 share purchase agreement. Why shouldn't that be taken into account? Even if I've been a bit slow in making the claim. I'm too late in making the claim under Swiss law. I'm simply asserting it by way of the old cliche, a shield, not a sword. So that's my first point. But the second point I make on limitation is this. Mr. Guy Vermeer was one of the claimant's witnesses. He was a Swiss law expert, and he was called to give evidence on a point about whether a certain debt had been, or rather, I think whether a certain debt had been repaid.
You have to rise here because he was a witness of fact. He was not a Swiss law expert, and it's important that the bench understands there was no Swiss law expert at trial.
We do understand that. No one called any expert evidence of Swiss law.
Yes.
Well, nobody called any CPR compliant expert evidence in accordance with the order that was previously made by the
That's right. And so it's just very important that the nomenclature of how Mr. Vermeer is described. He was a lawyer, a Swiss transactional.
But his evidence would be admissible as it is admissible, and no objection was taken to it being admitted, but it just doesn't have the status of a CPR compliant expert.
That's right.
I don't dispute any of that. Indeed, I was simply going to say he was called to give evidence on a point of fact. But I did ask him in cross-examination about limitation. And he was the man...
Foreign law is a matter of fact, so...
Yeah. Yes. And I asked him about it. I don't know to what extent I need to remind you of this, but essentially he was, and if I can summarise, his witness statement, we know who he was because he had been in practice for 33 years, quote, advising regularly on international and domestic transactions. He'd been managing partner of his firm from 2012 to 2021. That's the reference. That is supplementary bundle, tab 12, page 210. So he knows what he's talking about. And the cross-examination, where I asked him about the limitation period, is at supplemental bundle, tab 3, page 33, page 12, and supplemental bundle 3, page 36, paragraph, page 22. Perhaps I should take.
So you're going to have to. Sorry, I was just not fast enough to write all that lot down.
I'm terribly sorry.
Do you want us to go to it?
Perhaps I should show it to you because it's important.
The cross-examination.
Cross-examination.
So at 333.
3, page 33, tab 3, page 33, internal page 12.
Not in mine.
It's not in mine. Supplementary bundle, tab 3
Oh.
is the Novation Amendment Agreement.
Forgive me, tab 2, I do apologise. Page 33.
Yes, and within that, page 12.
Page 12, this is the beginning of cross-examination, just the first reference. He was Mr. Ortiz-Patino's lawyer. Halfway down the page, you assisted in drafting 2012 sale and purchase agreement. Is that right? That's correct, written in English. Any particular reason? English transaction, English buyers. Most of the commercial transactions in Switzerland are done in English. And then I take it to an invoice. That's more about, that's his involvement in the transaction. And then page 36, internal page 22. You can pick it up halfway down the page, line 12. Question. I'm not prepared to answer questions on behalf of MGI. That was on a different point. Thank you very much, Mr. Bene. This is my questioning. I dare say any claim would be statute barred. I don't know. You would know more about that than I do. In fact, what would the statute of limitations be for a contractual claim under Swiss law governed by the courts of Geneva? Answer, 5 years. Question, 5 years or 10 years? You said 5 years, did you? Then, he says, it's 10 years for a commercial contract, 5 years for lawyers' fees and functional fees. So 10 years for a commercial contract, correct. Questions such as, for instance, the sale and purchase agreement of 2012, which you helped to negotiate. Correct. Now, it is true that Mr. Vermeer was not tendered as an expert witness, obviously not, under CPR Rule 35. I say the following. There is a case on it, which I, if you like, I can take you to it. I say that is immaterial, because he obviously, as a matter of fact, had sufficient expertise.
Which is the case you intended?
Rogers and Hoyle.
Yeah, there's a rather more recent judgment of mine in this court.
Oh, my lord, I do apologise. I hadn't seen that. It's a Court of Appeal decision, Rogers and Hoyle, and
so is mine.
so is yours, well, obviously. But subject, of course, to what your lordship said in that more recent decision, the way the Court of Appeal dealt with it in Rogers and Hoyle was, well, very much the way you indicated before. Yeah. That is to say, it is not a necessary requirement that you have a CPR 35 report, compliant report. It simply goes to questions of weight.
Correct.
And that's it. And my lord, my lady, and my lord, if I don't need, I do apologise, I haven't got your case. But if it is to the same, essentially, albeit on a different set of facts, to the same effect as Rogers and Hoyle, you have my point. This is admissible evidence. It's admissible,
Subject to weight.
Subject to weight. And I respectfully submit.
Although usually it's the sort of cases that have been discussed, it's normally in the TCC or something like that, yes, where you have you have witnesses of fact who
yes,
are very well familiar with some of the technology, whatever, and for convenience, they are often asked to express expert opinions, opinions which could be expressed in CPR compliant form, but they're often allowed to do it to save the necessity to have CPR-compliant experts, but it is a question of fact.
It is.
It's Cleveland Bridge and Engineering, I think, was the case which, not my case, that was one of the ones that was referred to. Was Rogers and Hoyle from memory? Is that the air traffic disaster?
Yeah.
Slightly different point, actually, but
they considered the point more generally in relation to CPR 35.
yeah, see, if my memory serves me correctly, Rogers and Hoyle was actually about whether the air traffic investigation branch's report could be used in evidence, which isn't quite the same thing, but Cleveland Bridge and Engineering is on point.
Right.
And
Well,
I can't remember the name of the case. It was about who owned a sewage pipe in the northwest, and it was a decision given, I think, early this year.
My lord, I apologise that we haven't referred to it.
But don't worry.
I can say I didn't find it. Rogers and Hoyle makes the point perfectly plain. We do have that, and I'm conscious of the time. I can take you to the relevant passage of the Court of Appeal's judgment, or simply give you the reference.
Just give us the reference, thank you.
It is at page, in the authorities bundle, page 522, Court of Appeal's judgment, at paragraph 61 to 67, where they make the points that I've just made. It goes to weight. Now, in this case, my lady, my lords, I submit there's no reason whatsoever to disregard what Mr. Vermeer said. He is, on any normal footing, an expert. He, as I've said, he's negotiated hundreds, whatever it is. He knows about these types of transactions, and I specifically asked him, 5 or 10, and he said, no, it's 10, for this. And there's no contrary evidence. And that is the only evidence you've got. The question is it acceptable evidence? My submission, yes, of course it is. And it's not partial evidence, it's from one of their own witnesses. There's no reason to doubt the veracity of that evidence. That's what it comes down to. There is also this point. Supposing there is no evidence of Swiss law limitation, what then? My own friend, all he could do is rely on a presumption, at most, of similarity, that Swiss law has got a 6-year limitation period, or some, like English law. But he's got nothing. Unless he positively asserts that the presumption of similarity applies in relation to limitation, and therefore we have a 6-year limitation period, unless he positively says that, there's simply no evidence at all that the limitation period, of what the limitation period was. And if that's right, it follows that his limitation period for that alternative reason falls to the ground. So that's what I say about the general points of principle that arise under Clause 8. And now I want to go
Presumably you say the presumption of similarity can't apply to things as technical as limitation periods.
Yeah, I mean, they might, and I say they do apply to things like construing typical documents like the 2000 SPA, but you can't presume that the Swiss law's got a 6-year limitation period.
There's no sort of international harmonisation of limitation periods in commercial matters or anything like that.
And indeed, what we've seen from Mr. Vermeer would positively contradict that. So I submit the limitation point falls. Statute of limitation point falls. Now, I then turn to the specific facts on the second ground. That's, say, these little bulks of financial liabilities. As I've said, the judge accepted there were several other liabilities, apart from the interest to Mr. Cave, in existence at the time of the 2000 SPA, not disclosed in the disclosure letters. He accepts that. There is no dispute, but I just outlined this. Perhaps if one goes to page para 295, it's easier to do it by reference, I think, to this. Page 210, page 110, full bundle. Para 295 sets out the liabilities, the non-disclosed liabilities which the judge accepted existed and hadn't been disclosed. And there, first of all, there are 2 debts, to Mr. Galantes and to Mr. Murray. And you'll see 2/3 of the way down, Galantes is 117,000 euros, Murray 100,000 Swiss francs, which I appear to rather optimistically put at 128,000 euros. I think actually the exchange rate in 2012 was the other way round, so it should be more like 85,000 euros. I think I'm bound to accept 100,000 Swiss francs. It is not, was not that. So that should be 85,000 thereabouts. And it's accepted, you'll see, that these debts were settled only after 2012. So those debts are there. Now, there's no challenge, as a matter of fact, by my learned friend, to the fact that these debts pre-existed the SPA, but were not disclosed. So there is, on this ground, about no dispute as to about 210,000 euros. A dispute is now raised, however, on the others. That is to say, the VAT liability of 647,000 euros odd, the liability to pay property taxes of 156,000 euros odd, and the community charges of, judge put in 63,000, but I accept were in fact, I'm not quite sure where he got that figure, were in fact a total where they comprised 24,485 and 27,182 euros. And that you see in a schedule at core bundle, page 228, in items 12 and 13. But anyway, there are some disputes raised on that in my learned friend's skeleton. Now, on the VAT point, my learned friend says the judge made no finding that the 647,000 VAT debt was owed as at the date of the SPA. That's the point he takes. But in my submission, he obviously did make such a finding. If you look at 295, he says, second sentence, I would have been prepared to accept the liabilities to Galantes and Murray and certain liabilities that fall within this category and are referred to in the 2015 SPA as being summa zeta would form a valid basis for a claim for sell-off. So in my submission, the judge is plainly accepting that the 647,000 debt, VAT debt, was A, in existence, and B, not disclosed. He couldn't possibly have said what he said otherwise. I do also say this was Mr. Moxon's unchallenged evidence. And he gave evidence. I'll just show this to you. It's in the supplemental bundle at page 230. Paragraph 38. This is under heading deductions. And you'll see para 38, he's talking about the deductions which had all been set out under further information earlier. I've attached to the schedule, which was scheduled for further information, in this matter, a reference to the relevant documents or documents which evidence the deductions. I attached this schedule as so revised in the statement. I should add that had I known about the non-disclosed debts in column 2, I would have asked for indemnity or for sums to be put into escrow by drop from which we could recover the sums of the debts in the event they had to be paid. And then you go to the relevant document he's talking about, and that's at 161 in this bundle. Starts at 161. And this was a revised further information schedule giving references to the trial documents, and the relevant columns, relevant rows rather, are I think 30. It's at page 161. Begins. And 174, paragraph 36. And the second column, I should add, is got a heading at page 161, non-disclosed debt as at 12th of October. So what we're looking at is the, third column rather, is non-disclosed. So when you look at 36, the third column, you're looking down to see what he says was non-disclosed, and it's 647,000, and he gives references in the trial bundle. Now, there was no challenge to this. I should add, no challenge to this evidence. So there was evidence on which not only did the judge find it, but there was evidence to justify it, and no cross-examination to the contrary. The next question is, what about the liability to pay property taxes? My learned friend says there was no evidence that they predated the 2012 SPA. That's what he says, although the judge found that. But, my lady, my lords, first of all, it was not pleaded that these charges, or the IBIS property charges, post-dated the 2012 SPA. And more importantly, there was evidence that these charges predated the SPA. And that again is Mr. Moxley's statement. And if you look at staying in the schedule, item 12, column 3, is 24,000. This is one of the figures I gave you earlier. And 13 is the 27,000 figure. And page 174, item 35, is the IBIS charge, 156,000.
So, okay, I understand, I can see the IBIS property tax is the
Yes.
same.
Yes.
That I understand.
Yes.
So I'm looking now for the community charges of 63,000 odd. Where do I get that?
Well, my lord, forgive me, that was a point I mentioned earlier. The judge got that figure wrong. In fact, the right figure is the lower figure, which you see at 12, 24,468.
Sorry, did you?
And 13, I think I'm right in saying, is 27,000. So he's, I can't remember, it may be some...
So you mentioned he'd got wrong the
63.
debt to Mr. Morey.
No, forgive me, my lord.
Sorry.
He's got wrong the debt. When he said 63,000 euros in relation to community charges, that's where he went wrong. In fact, the figure is simply the total of what you see in items 12 and 13.
Sorry,
Rather,
so Mr. Calentes and Mr. Morey was correct.
oh, absolutely correct, yes.
Stated as 128,000 euros.
Except that was a wrong calculation on my part. 100,000 Swiss francs, I translated it the wrong way. 100,000 Swiss francs was not, and is not, and I don't think ever has been, 128,000 euros.
No, that's what I
It
got.
was 83,000 euros, and that's...
Okay.
So that's the correction. That's a correction of my mistake. Then the other mistake on the figures is the judge's 63,000 figure, rather than the figures of 24,000 and 27,000 in items 12 and 13. So I submit, just as a matter of fact, there is no basis for challenging the judge's findings. Now, my learned friend, that's what I call the first part of the second issue. There is the second part of the second issue. Were there further findings the judge should have made which would go against my client on these individual financial items? And what my learned friend says, as I understand it, is that we should have been fully aware from a Grant Thornton tax report that there were property taxes and community charges, that the property tax and community charges were outstanding. And what they rely on is simply this, what you see at page 183 of the supplemental bundle.
Sorry, page 183.
Of the supplemental bundle, item 62. Now, as I understand it, stand to be corrected, what is said is, now this is not, I should add, this is not a deduction we're claiming, but what is said is, if you look at item 62, they say, well, there was a Grant Thornton tax report and so forth, which we had claimed 10,000, but we didn't get that. Never mind about that. But they say that would have revealed the outstanding property tax and community charges, which we say, you didn't. You haven't even put that in evidence, certainly not before the court. So we say that's a non-point at the moment. Maybe my learned friend can clarify. But we also say this on this point. There was no plea, and there had to be a plea, that we were already aware of these liabilities. As you saw in the defence, they just said we're not going to deal with it. Second,
Well, okay, so let me just try and get my bearings again. You're saying that, sorry, if we go back to clause 8 set off,
yes,
it's a question of whether you shall have become entitled to
Yes.
assert. And it's said, is it that, so just so I understand the point being, as you understand the point being made against you, was that you weren't entitled to assert these claims because under Swiss law there was a defence that you knew about them anyway.
yes,
And so as a matter of breach of the SPA, you weren't entitled to assert, i.e. you had no good, or let's put it, you could have asserted it, but you could have been met with a slam dunk defence, which was, but you knew about them.
well,
You're saying breach of warranty, they're saying under Swiss law you knew about them.
well, they're saying, first of all, as a matter of fact, you knew about them. Yeah. I'm dealing with, for the moment, I'm just on the point of the facts. They're raising this as an extra fact, which they say the judge should have found. And we say there's no basis whatsoever for this allegation, that the judge should have found this fact. And the reason is, A, there was no plea. They didn't say, look, in relation to these community charges and things, you already knew about them. There's simply no plea about that. And second, it wasn't put to Mr. Moxon. So I submit the notion that the judge should have qualified his findings in relation to the property taxes and community charges is hopeless. It just wasn't even put, wasn't pleaded and wasn't put. Now, what all that comes down to is, as a matter of fact, on this ground, ground 2, is there's no basis for saying the judge should have made findings which would result, as a matter of fact, in a reduction of our claim below 1.24 million. And therefore, as a matter of fact, the court should proceed on the premise that a total of 1.24 million euros was not disclosed. Never mind whether that's a breach or not. That's the factual premise you have to proceed upon. The third question, third issue, is on the findings made by the judge, did the non-disclosures, as a matter of English law, give rise to a claim for damages in the sum of 1.424 million? And I say yes, they plainly did, because that was the non-disclosure amounted to a breach of clauses 3.9 and 4.9, which I've shown you before. Which I can show you again, my lord. Perhaps I can just take you to 4.9, maybe it's convenient to do so. Why we say this would be a breach. I'll go to 3.9. 4.9 is in the same terms, but I'll go to 3.9 for convenience. And that is the supplemental bundle at page 85. 3.1, it's the clause I showed you earlier. Except as fully and fairly disclosed, the seller provides the representation set out in this section to the purchaser. So, except as fully and fairly disclosed. So that, in absence of changes, 3.8 begins at 86, as I went to before, and then 87. 3.9, neither Holdco nor Campo Alto has incurred any liability, prospective, contingent or otherwise, whether arising on or after claim, including but not limited to any liability to any advisor, agent or other person not settled prior to claim. Those are the warranties we're given. That's the warranty, and I submit these liabilities were a liability, constituted a liability. Which was not disclosed. And therefore, as a matter of English law, one would say non-disclosed liability. As to the question of loss, I submit on the face of it, one would say, well, the loss is the sum that we've paid, the greater sum we've paid of 1.24 million, which would not otherwise have been paid. had we known about this liability. Why would one? It's important in this context, my lady, my lords, to note that the 2012 SPA, like the Zagaleta SPA, was not one which was where the price was being assessed on some profit-earnings ratio or anything like that. These were heavily debt-laden companies, and essentially they all take about, in our case, taking on debt, and in Zagaleta's case, taking on debt. So the more debt there was, the more allowance, the more disadvantageous the transaction became, wherever the debt was placed within the corporate structure. So I say on the face of it, there's a loss of 1.24 million, but Mr. Moxon's evidence, which I did show you a moment ago, where he said he would have wanted an indemnity against these various liabilities, had he known about them, that wasn't challenged, and of course that is obviously right. That's exactly what one would ask for, if you know about these liabilities, or indeed the possibility of these liabilities. So I say, as a matter of English law, there was a breach which entitled my clients to an indemnity or damages in the sum of 1.24 million euros. Question then arises, what about Spanish law?
Spanish law?
So, I keep making that mistake, and I do apologise. What about Swiss law? And for that, obviously, one needs to go to Lord Legate's speech in Brownlee. The reference, can I give you just I don't propose to go to all of it, it's a long judgment, but the points, the paragraphs that really matter, in the tab 10 of the authorities bundle, page 208, paragraph 119 going over to 133, and then page 215, paragraphs 145 to 146. And in particular, if I may just take you to certain paragraphs of his judgment, which I submit are relevant to this point, the presumption of similarity, and would it be appropriate in a case such as this to apply it. And first one starts at a paragraph 123, which is, I think, around page 209, thereabouts.
I'm sorry, you said authorities 10?
Oh, 7.
7, thank you.
I hope, yes, I think.
Yes, it is 7, thank you. And you were taking us to paragraph?
1, 2, 3.
Thank you.
He begins his discussion 119, talking about academic criticisms that should be made of the rule. But the important paragraphs, for my purposes, are paragraphs 1, 2, 3 to 1, 2, 6, and yes, to 1, 2, 6. And my lady and my lords, can I invite you to read those to yourselves, and I shall make a few points on them.
Thank you.
And at 145, he says that the presumption is less likely to be appropriate where the domestic law is contained in the statute. Well, that is the case with the limitation. I mean, the assumption that any other jurisdiction would adopt our patchwork quilt of limitation is perhaps one that I wouldn't want to make very readily.
No. Few people would choose our law of limitation. That's a different point.
I'm not sure it is that different a point
Well,
is it? In this particular case. Isn't that rather the point?
yes, well, it is. I mean, that's our point here. I mean, obviously, on the presumption of similarity, can't seriously apply to limitation points, we'd say. But we are, just, if I may go back, just on what you might call the merits points, because I'm dealing with this not so much in the context of statute of limitations, but the essential question is, if this matter was
contractual interpretation
of this type of contract. I just want to draw 4 points from the paragraphs 123 to 124, which I took you to. The first is, in paragraph 123, you'll note, Lord Legate cites with approval what Lord Justice Mustill said in Muduroglu, where he observed that in so many practical respects there is insufficient difference between the commercial laws of one trading nation and another to make it worthwhile asserting and proving a difference. The same insufficiency of difference will often make it reasonable to start from an assumption that the applicable foreign law is likely to be materially similar. You don't have to show identical, but materially similar. And then, 124, the requirement of materiality is the second factor. It's important to keep in mind. And then I particularly emphasize this, unless there is a real likelihood that any differences under the applicable foreign law and English law on a particular issue may lead to a different outcome, there is no good reason to put a party to the trouble and expense of adducing evidence of foreign law. The object of adjudication is not to achieve a goal of abstract legal purity, but to do practical justice. And then 125, the presumption of similarity doesn't determine the legal issue, but it only operates unless and until evidence of foreign law is applied. And then 126, the conclusion. There's good pragmatic reasons for applying the presumption in a range of places, and so range of places. Now, I say, applying that, and also what Lord Legate goes on to say, I think it's in paragraph 140 in a conclusion, at 145, I think, 144, 145, perhaps my lords, you should have a look at as well, which they form the conclusion. So I derive 2 points from that. 145, 144 is great and broad principles of law likely to impose an obligation in all developed systems. 145, you don't necessarily apply that to statutes, and specific examples are given, which are obviously completely different from this type of case. And then thirdly, 146, it's up to the parties themselves to decide which way they want to play this. And it's certainly not the case that if a party in my position doesn't adduce evidence of Swiss law, that the court's hands are in any way tied. It's always open to the other party to adduce evidence itself. So we say, on the facts of this case, the presumption of similarity is appropriate, and we summarise this in our skeleton, but if I can just say them again. First of all, true it is that the 2012 SPA is governed by a Roman law system, but it is written in English and, most important of all, using unambiguous terms on which there can be no serious question of construction. It would be very different if there were difficult terms in this. I might well say, oh, I don't know what a Swiss lawyer would say. But here, there's no reason to suppose any Swiss lawyer would place a different interpretation either on the terms or indeed the remedies for breach of non-disclosure, for the breach of disclosure obligations. And I particularly make these points the 2012 SPA is full of concepts recognised under English law and all round the trading world, representations, warranties, and so on and so forth. I mean, frankly, one could have looked at that document and seen it was governed by English law and not be remotely surprised. Second, it's drawn up by professional lawyers who have essentially incorporated its provisions into the profit share agreement, which was entered into at the same time and governed by English law. I would respectfully submit that if, in fact, it was thought that there was a substantial difference between the interpretation methods of English law and Swiss law, the parties would not have, lawyers would not have provided for that. Thirdly, I say there is no reason to suppose that Swiss law would take a different view, generally speaking, on whether the facts we allege amount to a breach of contract or indeed the remedy. And indeed, there is simply none. It's not a case where you've got the realistic alternatives to what we say, put forward by the appellant. And all they say is essentially, at least in their skeleton, is, quote, it is unclear how Swiss law would approach these matters. But that's not the question. The reference is page 209 of the core bundle, para 124. The question is not whether it's clear or not. The question is there a real likelihood of a difference? And in my submission, there is no basis for supposing a real likelihood of difference. And therefore, I submit, on this second ground, the court should make the following findings. First, on the judge's findings of fact, there was a breach. Secondly, this would give rise to a claim in damages of about 1.24 million. It should perhaps be a little bit less to account for the differences which I've mentioned, which I think probably total something in the region of 70,000 euros odd. But subject to those adjustments, it's in the region of 1.124 million. Let's say 70,000. I regret I haven't calculated precisely what the difference would be. And therefore, as the judge's findings stand at the moment, that would give rise to a complete settlement. Now, just the fourth issue, I can deal very briefly with this, is if the judge should have made other findings, as alleged by my learned friend on this, then how does this affect the matter? Well, I say it doesn't. First of all, there's no basis for saying the judge should have made further findings. And secondly, all that these further findings would affect would be the sums of 156,000 and 52,000 for the community charges, I think the various taxes and community charges. But that would still reduce the claim only to about €1 million. And I also say, this being the nature of the complaint, the judge should have found that we knew certain things. I say, on a proper construction of the Swiss law contract, there's no basis for saying the fact that we should have known something could possibly form a defence to a claim for breach of the warranties, because it is except as disclosed. And that's certainly how English law would approach it, and I respectfully submit that's how Swiss law would approach it too, because the words of the contract are clear. My primary point is you don't get there because it doesn't arise on the facts, but my secondary point is even if you do get there, and the allegation is you should have realised these liabilities existed, I say, why does that give rise to a defence in English law or indeed Swiss law, where the wording is clear? Is there a real likelihood Swiss law would take a different approach on that? You could have realised, you should have realised, or would it just say, you signed up to this contract? So I say you should apply the presumption of similarity, even if, contrary to my main point, we should have known of some of the liabilities which we complain about. But the other points are that they don't make much difference anyway, and there's no reason for saying the judge should have found them. I then turn to what is our first ground, which is the interest heuristic. That is to say, our liability with the liability which we had to pay the town of Castellar for the planning consents of about 1.418 million. The judge says 1.42 million, but I accept the right figure is 1.418 million. And we say the claim that A, the liability, contingent liability existed as at the date of the 2012 SPA, B, it was not disclosed, and C, the sum eventually paid, 1.41 million, we say all of those are clearly established by the evidence. Now, the first question with this claim is the same as the first question in relation to the other claim I just mentioned, namely, does it fall within clause 8.1? And I say, yes, it does, for all the same reasons. There is jurisdiction, it's not made too late, there's no question of limitation. The liability, or the contingent liability, had arisen, it seems, sometime in 2011, but it wasn't disclosed. The breach occurs when it's not disclosed in 2012. And it had therefore arisen, the breach had therefore arisen before November 2015. The second issue is, first point, is there a basis for challenging the findings of fact made by the judge? And you can see the judge's findings at page 109. I took you to this earlier. The judge finds, he summarizes the case at 288. Perhaps I could just ask you to read yourselves 289 to 292. I think I've already referred to 293. Now, the first point we make is the judge has found that a contingent liability has arisen, and there is no doubt equally on the fact that it was not revealed in the disclosure letters. There's no doubt about that. I'm just talking about the facts for the moment, and we set out in our skeleton the nature of the evidence which gave rise to that finding of fact, and that is at page 305, paragraphs 45 to 46. And I don't apprehend that my learned friend disputes that the evidence justified the finding. The relevant reference, I can give you just the relevant references in the evidence, the cross-examination. First of all, Mr. Felipe Ortiz-Patino's evidence in the supplemental bundle at page 22. Lines 7 to 15, where he accepts that once the quote, plan especial had been granted, the fee would be payable to the town depending on what could be negotiated.
So that reference was, can you give it again? Supplemental.
Page 22.
Page 22. Page 22. I think
Yes, yeah, sorry, then you didn't give us the internal page, you just gave us a line number, I think.
Oh. I think it's actually just 7 to 15 because that, unlike the other parts, is in broad space.
Oh, I see.
I think.
It's open text, yes.
Open,
Right. Oh, okay,
Yeah.
7 to 15. Fee is going to be payable once the plan especial has been granted, and you'd have to pay something depending on what you could negotiate, essentially. And he says that the requirement to pay was in the plan especial, which is a public document. Come to that separate point later. And then he discusses at page 23, line 1 to 24, line 25, what the likely extent or amount of the fee would be. And essentially, it wasn't going to be nothing, and the amount was likely to be about 1.2 to 1.4 million. That's what it eventually comes down to. 23, line 1, I think, to 24, line 25. and especially at page 24, lines 22 to 24. That's very good. You also accepted, page 31, line 22, that if you didn't pay the fee, it would be difficult to get the necessary license to develop the land. In other words, you've got to pay the fee, otherwise you can't develop. Page 31, line 22. Going over the page to line 11.
If you didn't want to develop, you wouldn't have to.
Yes, that's true, but there would be not much point buying the land. And can I just say this, my lord, on the wording, it's not just contingent liability, but prospective liabilities. But I would submit that if you are going to have to pay, if you want to develop, then that constitutes a contingent liability. And indeed, the sum was then paid. My lord, I can see my lord quizzing whether that could be right, but in my submission, this would amount to a contingent liability.
Well, if the contingent liability is that you decide to do something yourself, I mean, normally contingent liabilities are liabilities which you have to pay if some event occurs.
As opposed to if you make a decision yourself.
As opposed to just it's an expense which, if you make a decision to do X, you will have to spend Y. It's difficult to see that's not a contingent liability. I mean, that's dependent upon your own choice. That's not normally what you'd say is a contingent liability as a matter of English law.
Well, I would say prospective.
Not even prospective, because you're under no prospective liabilities where you are under a liability to pay a sum of money which falls due in the future. Current liability to pay something in the future.
Well, my lord, I would submit it did constitute a contingent liability in practice.
Have you got an authority that
No.
would, as a matter of English law, as to what contingent liability means?
There is one in the bundle, which my learned friend, I think, has put in the bundle, which does discuss what the nature. Sorry? Nortel. Is it Nortel which discusses it? Yeah. My lord, can I perhaps, I'll deal with the law in a moment, if I may, just focusing on the facts. My learned friend says, in relation to this ground, that the judge should have made two further findings. First, there was publicly available information from which we could have found out about the interest to Ristico, and that, I think, is in part based on the evidence I showed you. Secondly, that Mr. Spencer, who at the time, I think, was the director of MGI, knew about the interest to Ristico, and so you should attribute his knowledge of the interest to Ristico to my client. But I says to that, there's no basis for saying the judge should have made either of these findings, because neither point was pleaded as a defence to our claim. It was mentioned in the defence, but only in the context that we should not have signed an agreement to settle the town of Castellar's claim for 1.4 million. And one can pick it up at, I think, it's page 132, the amended particulars of claim, and supplemental, and the core bundle, paragraph 59B.
Page 132.
132, paragraph 59B.
Mm-hmm.
Begins at the foot of the page. The defendant's mismanagement of the Valderrama Group includes, and then we'll see over the page, signing on favourable agreements, and so forth. We denied that, page 151, paragraph 38A. And then that is in turn dealt with, I think, in the reply at page 180, beginning at 181, page 72A. And then where they set out what they say we knew. What they say.
181 paragraph.
Sorry, not where they set out what we knew. 72A, then page 182, subpara E. This is in response to what we said. They say Valderrama signed the agreement. This involved the compensatory elements of local authority, which was a legal requirement. The requirement to pay the local compensation was set out in the plan especial, and so forth. But that's all it says. In other words, they say there was indeed this liability to pay, but...
Well, it would... I mean, I'm struggling at the moment. What I'm still struggling to get past is that there's no actual liability. It's simply that if you want to develop, you will have to pay a fee.
Well, my lord, I'm not sure we accept that evidence. That's certainly what Mr. Felipe Ortiz-Patino, I think, said in that passage. But as we are, well, our position is that fee had to be payable because we'd actually got the permission. And that's what he appeared to be saying earlier. My lord, I understand the point you're on. Is this a contingency, so to speak, within our own power, and therefore not really a contingent liability? It's only if we decide, go ahead. But can I, I'm just for the moment on the facts, can I just deal with the facts first, then come to the construction? Now, I respectfully submitted, on the judge's findings of fact, we have a good claim for saying that there was non-disclosure of a liability, come to your lordship's point about contingent or not, to pay 1.42 million, and there was therefore a breach of 3.8 and 4.8 on the footing that this was a contingent liability or prospective liability, or indeed, I think 3.8 says or other liability. I can go to 3.8 if I can just go back to that. The SPA. Page 87, I think. As neither companies has incurred any liability by the prospective contingent or otherwise.
Has incurred a liability.
Yes, has incurred. Well, my lord, it has incurred the liability if we wish to make use of the land. I mean, the liability, it will have to be paid for if and when you get your building license. You might not apply for a building license. The highest it goes is, if you don't apply for a building license, you won't have to pay. But if you want to get your building license, you will have to pay. Query, is that a contingent liability? But in any event, I say on the judge's findings, I hope I can take this quite briefly. I'll come to the law in a moment. I'm conscious of the time. I'm also conscious that if I'm right on the other ground, none of this matters. But can I deal briefly with the question? I say on the first point, the judge's findings do give rise to a liability, as a matter of fact. Query the Spanish law position. The second point is whether the judge should have made further findings. That is to say, Mr. Spencer knew about the interest heuristica, and anyway, all this was publicly available information. Should the judge have found those two facts? And I submit no, as a matter of fact, because it was not pleaded that Mr. Spencer knew about the interest heuristica. As simple as that. And there was no challenge to Mr. Moxon's evidence that Mr. Spencer did not pass on whatever knowledge he had to the board of MGI. As to publicly available information, I would accept that the judge could have made that finding. There was publicly available information. The question then arises, well, does that make any difference as a matter of English law or Swiss law? And we say as a matter of English law, neither of these things makes any difference. As far as Mr. Spencer's knowledge is concerned, the fact that he knows, and he's one of the directors, the fact that he knows cannot operate as a defence to the non-disclosure to MGI of this liability. And we say in particular, his knowledge was irrelevant because he was himself one of the other contracting parties. He was acting, I think I'm right in saying, as a director on behalf of Stripe, this on the Novation and Amendment agreements. So to attribute the knowledge of a director who is acting on the other side of a transaction to us, I submit, would be wholly inappropriate. Even if he might be appropriate to attribute his knowledge to us if he were acting solely for us. But to say that a director who's acting on two sides of a transaction, to attribute his knowledge to both sides, I submit, is wrong in principle. We have put in the bundle of authorities the Singularis Holdings case, where this was all about fraudulent directors and whether you attribute knowledge of a fraudulent director to a company, where the Supreme Court said, in essence, well, it's all a matter of context. And we say, the context being what I've described, it's inappropriate to attribute Mr. Spencer's knowledge. I don't think the relevant passage in Singularis is at Authorities 16, I think it's paragraph 34. So we say it's irrelevant as a matter of English law, if Spencer did know, which we deny, and as a matter of English law, does it matter that this was publicly available information? We say, couldn't matter less. The disclosure letter is clear. What about Swiss law? And we say you apply the presumption of similarity. On the point, I think that my Lord or Justice Snowden was pressing me on contingent liability. If I may just, I think it's Nortel, tab 11 of the authorities bundle, and there is a discussion about what is meant by contingent liability in an insolvency context. And the relevant passages which bear on the point. But first of all, page 40.
Let's be clear, this is all about whether a financial support direction, which would be issued by the pensions regulator, could be said to be a contingent liability.
Yes.
So it's entirely to do with a contingency which relates to the actions of a third party.
Yes. Which you would say, I think, as I understand it, would say, well, that's different from a contingency which depends in part on the individual.
Well, I have to say, I've yet to be shown an authority where your own voluntary decision to take a step amounts to a contingency for the purposes of insolvency or indeed any other law.
Well, my lord, as I've taken to this, and
but I mean, you understand the point I'm making. Every single case that, this case and others that preceded it, which I was involved in some, all were to do with steps which somebody else may take, or an event which may take place outside of your own volition and control, which might render you liable to pay a sum.
Well, there is a general discussion. You'll be familiar, obviously. I expect your comments. It's on page 405. Is a recitation from judgment of Lord Street of Lord Reed and Henry Sutherland. And you can pick it up at 78. That case concerned whether an arrangement was in the expression contingent liabilities in Section 50 of the Finance Act. And as Lord Reed explained, if an act says I must pay tax if I trade and I make a profit, I'm not before I begin trading under a contingent liability to pay tax in the event of my starting trading. In neither case have I committed myself to anything. But if I agree by contract to accept allowances and so on and so forth, So I think, my lord, that would be the point you're on until I've actually committed myself to a particular course. I'm not under the
I am
liability.
not before I begin trading under a contingent liability to pay tax in the event of my starting trading. And the point is, you can decide whether or not to start trading. You can't say, I'm under a contingent liability to pay tax because I'm thinking about starting trading before you have. And in neither case have I committed myself to anything. But if you do commit yourself, then that's different.
Just over the page, my lord, paragraph 82. I note that the approach to contingent liability adopted in Sutherland is considered helpful in 2 cases. In the latter case, the judge pointed out the case before him was, as these cases, in one important respect, stronger than Sutherland. The majority did not regard as decisive that the liability to pay the balancing charge would arise only as a result of the company's choice to sell ships. In this case, there is no question of volition.
That's a reference to Mr. Justice David Richards,
Yes.
who then was in TNN, which was to do with asbestos liabilities, which I was counsel.
Well, my lord, you have my submission. In reality,
I mean, just to be clear, that was a case where the company had traded. It had incurred potential liabilities contingent liabilities to its employees for exposing them to asbestos. It had done what it had done, and it would fall under a liability if and when the employees developed asbestos-related illness. I mean, what had been done by the company, but it was not, it was no longer a question of whether the company was going to do something. The point is it had done it. And the question was simply, would people develop asbestos liabilities or not, and could you compromise them under a scheme of arrangement?
yes.
Held yes, you could, because it's a contingent liability, because the company has done something which exposes it in the happening of an event outside its control to a liability. And that's what Mr. Justice Dave Richards then was, I think, meant when he said in this case there's no question of volition. The point is the company had done it, and it wasn't up to the company to do anything else. What had been done had been done. I think that's the context.
Well, my lord, you have my submissions. I say on the facts of this case, the whole point of the proposal was that we would buy Campo and develop it, and hence what you see in the PSA, with a provision of 16 million price, I think, as the price above which would be the price above which.
Presumably, you would have to, if you were going to develop it, presumably you would have to employ other people to do it. Were those contingent liabilities as well that should have been disclosed?
Well,
we get builders in to build it.
This is
We'll instruct lawyers.
One can see the difference there. This is a particular liability which is imposed in return for the interest risk, as well as the development license. But if you don't decide to develop, taking that as highest, if you don't decide to develop, then you won't have to pay it. I say that's a contingent liability where the circumstances are such that the intention is obviously that I will develop it. But my lord, you have my submission, and I don't want to take more time. My lord, my ladies, my lord, can I just go to the third ground? I've dealt now with the first two grounds, and I say, whatever the obstacles on the second ground, and I can see there are more what you might call points, there's nothing on the first ground. Sorry, but I say first, the ground I developed first, which is in fact the second ground.
And you're moving on to ground 3.
Ground 3. Now, the purchase price was 20.6 million. And the judge deducted various deductions under clause 3.3, as you've seen earlier this morning, which totalled 11,706,518.64 euros, under clauses 3.3 and 4.21. You get that from page 103 of the core bundle at page 263.
Paragraph 263.
Para 263.
Can I just, out of interest, on the previous point we were on,
Yes.
the judge said, so I've just lost it temporarily, he said that, 293,
Yes.
there is no dispute, however, that a contingent liability had arisen. What did you mean by that?
Well, I think just that. That, I don't think there was any dispute on that. Oh, I'm being handed. Ah. Well, my lord, can I say the judge didn't find in favour of that evidence from Mr. Felipe. And I'm told, in fact, that my clients were sued for the payment of the fee, and it was eventually settled at 1.4 million.
Sorry, sued by who?
Castellar del Frontier. By the town.
By the city.
By the city. They sued before any building, before anything had taken place, because nothing took place. So they were sued in any event.
And you presumably had a defence?
No, we settled up at 1.4 million. No, because in other words, we don't accept what Mr. Ortiz-Patino said in the witness box, nor does the judge. He certainly doesn't mention it.
You were paid at paragraph 263, which is your point on ground 3.
Yes. Ground 3, 263, page 103.
And the last sentence doesn't, the map doesn't include any set off which would be available.
Yeah. So there's the 11.706 million, and that's for under clauses 3 and 4.21, and you get that reference from 262. Now we say that there were 4 other liabilities which we took on or assumed under the 2012 SPA, which constituted liabilities under clause 3.3, and therefore we are entitled to have deducted, which total 7,344,056 euros. 7,344,056. Therefore, we say the total deduction should be increased by that amount from the 11,07518. I think you would therefore get a total allowance of 19,050,574. That's, we say, the total. It should go up, in other words, from the 11 odd to 19. And that, in turn, would reduce the net profit to about 1.6 million. With the sale price being 20.6 million. So we say the third ground doesn't get us home entirely, but it certainly very substantially reduces the claim if it exists and is not extinguished by the other set-off I've mentioned. Now, my learned friend says we need leave to pursue this point. And I say in answer to that 2 points. One I mentioned earlier. It is a point which I'm entitled to take in addition to the other grounds I've made. And if my other grounds succeed only up to a certain point, but not a sufficient point to get me to a set-off, complete set-off, then I'm entitled to rely on this point as well.
That's a little bit hypothetical, isn't it? It's quite difficult to see that arising in practice, because your points are quite binary in nature.
They are, but you never know my law. Anyway, I agree.
That's why I say it's hypothetical.
Yes, but I also say it's hypothetical, but my learned friend would often disagree entirely. But I do also say this. If I need leave, then I should be given leave, because these points arise very much out of the same points as made by my learned friend in relation to the 8.8 million deduction. It's all about what deduction should be made on a proper construction of the agreement. What are the proper allowances? If the agreement writes on these circumstances. And I also say the points are plainly arguable. What we say right, but that's a different point. The first deduction we claim is for 3.5 million. This was a sum which we paid to Mr. Ortiz-Patino to enable Mr. Ortiz-Patino to settle various debts.
Just to be clear, are we about to be taken to the judgment where the judge deals with these points?
Yes.
Right, okay.
The judge explains the point at page 97. Para 246, subparagraph 2. just going to ask you to read that. And a rather longer description is given of the arrangement at page 38, paragraph 66.2. Sorry, 66.1. And we have the document itself. It's rather bad shape, I'm afraid. There's nothing I can do about that. At the relevant document in the supplemental bundle near the very end, at page 221. And you can just see the background. This is a letter from my client to the banker beneath. Background, we understand that the debt provided by beneath to Mr. Ortiz-Patino and Valderrama 07 is one figure, and then 3.5 million odd to Valderrama 07 falls due on the 7th of May. We will acquire this debt from beneath for the net amount of the debt mentioned above minus the sum of various sums. And then further details are given of the offer.
So I can't even see where. 221. Where are you reading?
Oh, sorry, 220. I do apologise. Sorry, I was reading 220. I do apologise.
Sorry.
Background, and the third way down. My client's writing to the banker beneath. We understand that the debt has been provided by beneath to Mr. Ortiz-Patino is, as the second item, 3.5 million to Valderrama. MGI will acquire this debt from beneath for the net amount of debt mentioned above minus the sum of, with, I don't think, particularly significant. And then you go to the offer on page 221. And it sets out at greater length on the second paragraph under the heading offer, where it says they're willing to take on, essentially, debts.
But no further reference to the
No, not the 3.5.
3.5.
But there is no doubt, and the judge, I think, finds that that is taken on. There's no doubt that that is a liability that we took on. The judge rejected this item at page 116, line 45.
Sorry, page 116, paragraph.
Item number 45. That's just the schedule where he just says, and perhaps I should take this, he may make some comment. I think he just says it doesn't fall within 3.3.
So 160, item.
45.
Thank you. I'm sorry.
He just says, so his reasoning is it just doesn't fall within clause 3.3.
What do you say it falls within?
3.3.
Point.
3.3, I can't remember, 1, I think, the financing provision.
Bank facilities or other financing secured on or utilised in relation to the real estate asset.
Yes.
Was it secured on the Soto shares?
It hadn't been secured on the Soto shares, no. I think it was been secured on the Valderrama. It was essentially a loan to Valderrama. It might have been secured on the Soto shares, but I just say this was...
Well, hang on a second. If Sorry, so this is a bank loan made by Banif to Valderrama.
Yes, and I think secured by Mr.
Valderrama's 07.
Yes, which is not Soto.
Right.
But I say that doesn't matter. I say
Cool.
Under 3.3, the question is taken in the round.
It has to be a sold real estate asset.
If I go to 3.3, forgive me for a moment, my lord. Utilised in relation to such real estate asset.
No, it has to be attributable to sold real estate asset. That's
Yes.
number one. So what is the sold real estate asset
Soto.
that it's attributable to?
It's notionally attributable to Soto.
Why? You just told us it's secure. It was a loan made to Valderrama 07.
Well, I accept that, but nonetheless, in order to buy Soto, we had to pay that off in order to get Soto. It's as simple as that, my lord. We say this is a
It's not very
liability.
simple. Sorry, I'm struggling to join the
But
dots.
my answer is as simple as that. Whether it's that's what I meant. We say this was a liability which we had to incur. Indeed, a banking. It was a banking liability which Mr. Ortiz-Patino had. It's a liability we had to assume in order to acquire Soto and Campo together. We couldn't have acquired Soto and Campo together. We couldn't have got Soto on its own unless we paid this off. That's the only point. And therefore, even if we cannot have all of the 3.5 million, we should have at least half of the 3.5 million. And we say this in our skeleton. Because it is a sum which is referable, which we had to pay in order to pay off Job's debts and in order to get our hands on Soto and Campo together.
Is that a convenient moment, Mr. Knox?
Yes, I'll be very brief after.
Well, I was going to ask you, how much longer have you got?
10 minutes, if I may. Squeeze it.
Because between the two of you, we have to finish as a complete long stop of 4 p.m. today. And therefore I'm asking, depending on your situation, despite the fact that it's already 1:05, whether we recommence at 1:45. Is that necessary, Mr. Blaker?
I'm very much in your hands. I mean, I would hope to be much briefer than
Fine.
Mr. Knox, but
On that basis, we'll say 2 o'clock, but we have to rise at 4 p.m. at the very latest.
yes, that's noted.
No,
Thank you.
my lady.
All right.